that everybody is joined. Okay. Yeah. We finalized the argument of Mr. Donen SC yesterday. So today we'll proceed with the arguments of the first respondent, which will be presented by Advocate Maleka and Advocate Mandlakayise. Are you ready to proceed, gentlemen?
Good morning, Judge. My learned friend, Mr. Mandlakayise, will start first for the JSC.
Okay. So, Mr. Mandlakayise, as I did with Mr. Masuku, I'll give you the first 15 minutes uninterrupted so that you can settle well. I can see that you've got some cold feet.
Yes,
just misleading me.
I do. I'm actually shaking under my desk.
Fortunately, we can't see that. Okay. Colleagues, can we start?
Yes, thank you.
Thank you.
Thank you. Okay, you can proceed, Mr. Mandlakayise.
Thank you, TJP. If I may then proceed, we say that the case presented on behalf of Judge Hlophe is legally misconceived. It is divorced from the facts and it produces absurd consequences. The only issue that I will be addressing is the question of the composition of the JSC. We argue that the JSC was properly composed and there is no proper basis to question the composition. We say that even if the court is in doubt about the composition, this is not a proper case for the setting aside of the decision. Let me start with some facts just to lay a proper sequence. But I must make it clear that Mr. Maleka will be dealing with the same facts, but in the context of the merits-based review. But my facts is simply to set out the bare bones of what I'm about to submit to the court. The starting point is the complaint against Judge Hlophe. That complaint in the form of a charge sheet you will find at 0084184 up until 0084189. There are just two features of that complaint that I have to highlight. The first is that at 4185-008-4185, Judge Hlophe was charged with gross misconduct. The second feature, with gross misconduct involving an acting judge of the Constitutional Court, Judge Hlophe, and Judge Nkabinde. The second feature of that charge sheet is that Judge Hlophe's misconduct, as you can see at 0084186, was said to be directly in breach of the Constitution. He was charged for violating Section 165(2) and 3 of the Constitution. And that related to four cases. It was Tint versus NDPP, Zuma versus NDPP, Tint versus NDPP, again Zuma versus NDPP. Those were cases pending at the Constitutional Court at the time. In fact, they were heard on the 11th and 12th of March 2008. The final version of that charge sheet was read into the record and on the 8th of December 2020, when the proceedings commenced. That you will find at 0084295 up until 0084299. That's where they read out the full version of what he was charged with. The decision of the tribunal following this charge, the court will find at 0085638. It is, if I may say, a very learned and thorough exposition of the facts and the law, which I respectfully commend to the court. Written by, well, signed by Judge Lapuska, Judge Mahoka, and Judge Patha. What it finds Judge Hlophe guilty of is at page 008562 at paragraph 123. It's crucial to note this. It says, in conclusion, on an objective and proper consideration of the facts and probabilities, we find that Judge President Hlophe's conduct breached the provisions of Section 165 of the Constitution, in that he improperly attempted to influence the two justices of the Constitutional Court to violate their oath of office. Then in B, it says his conduct seriously threatened and interfered with the independence, impartiality, dignity, and effectiveness of the Constitutional Court. And then C, his conduct threatened public confidence in the judicial system. Those are the three findings against Judge Hlophe. He breached Section 165 of the Constitution because he tried to influence judges to violate their oath of office. His conduct actually interfered with independence of the Constitutional. His conduct threatened public confidence in the judicial system. And this is why at paragraph 124, it is then recommended that impeachment proceedings should be commenced against him forthwith. The matter then came before the Judicial Services Commission, and the ruling the Judicial Services Commission, I'm talking about the majority ruling, not the minority opinion. The operative ruling is at page 0085565 up until 0085598. It endorsed in full the learned reasoning of the Judicial Conduct Tribunal, in full. In other words, where matters stand, Judge Hlophe is guilty of violating the foundational law of the country, Section 165 of the Constitution. Judge Hlophe has actually interfered with the independence of the courts. Judge Hlophe has eroded public confidence in the system of adjudication. That, of course, is crucial to keep in perspective as we debate the question of the proper or improper composition. When the matter then was at the JSC, some of the facts again require some recounting. The first one is that Judge Zondo had been disqualified to sit in the Constitutional Court when the case of Hlophe versus Premier of the Western Cape was heard. That the court will find at paragraph 81.1 and 81.2 of the answering affidavit 012/31. So Judge Zondo, who was at the time the acting Chief Justice, had been disqualified because he had been a party to mediation efforts in respect of Judge Hlophe when the complaint first arose. The second thing to recall, which is set out at paragraph 128 of the answering affidavit, is that Judge Mogoeng, the Chief Justice, was on leave from 1 May 2021 to October 2021. So during the entire operative period, which was between June and August 2021, Judge Mogoeng was on leave. Judge Zondo had been disqualified from sitting at the Constitutional Court as a consequence of his mediation. That's the pleaded case. Now, at paragraph 129 of the answering affidavit, it is also explained that the practical situation, at least in May and June, was that Judge Zondo could not sit in any event, regardless of his own conflict, because he was chairing the State Capture Commission of Inquiry, which resulted in the appointment of Judge Hampempe as acting Deputy Chief Justice. between 1 May 2021 and 30 June 2021. So when the first meeting of the JSC, which considered this matter, and that's pleaded at paragraph 130, was convened on 4 June 2021, it was Judge Hlophe, properly and duly appointed as acting Deputy Chief Justice, who chaired that meeting. At that meeting, the report of the JCT of Judge Hlophe was presented. There were different opinions, but there was no final decision. The matter was then deferred for consideration on the 20th of July. As it turned out, it was not considered on the 20th of July. But also, Judge Hlophe's term as acting Deputy Chief Justice had lapsed with effect from the 30th of June. The matter turned out that it had to be dealt with as alleged at paragraph 132 on the 25th of August 2021. At this stage, Judge Zondo was back, but he was still conflicted on the objective facts. It was considered on the 25th of August 2021. Judge Hlophe should be appointed as acting Deputy Chief Justice. That was entirely lawful because under Section 4, subsection 2, subsection A of the Superior Courts Act, the Deputy Chief Justice performs the functions of the Chief Justice as acting Chief Justice in the absence of a Chief Justice. Judge Mogoeng was absent. His leave only lapsed in October. Judge Zondo assumed the role of acting Chief Justice, and therefore there was absence at the level of Deputy Chief Justice. Judge Hlophe then became appointed for the 25th of August 2021 as the acting Deputy Chief Justice. The appointment of Judge Hlophe is at 0085446. That's the presidential minute, which shows that Judge Hlophe was appointed on the 23rd of August 2021 for the date of the 25th of August 2021 by the President to be the acting Deputy Chief Justice. That minute makes it clear that that appointment is done with the concurrence of the Deputy Chief Justice, the substantive Deputy Chief Justice, who was Judge Zondo, who is acting as the Chief Justice. So at the time, Judge Zondo was playing the role of Chief Justice, and Judge Hlophe was appointed acting Deputy Chief Justice for that day. Now, then the facts that are crucial, those are the facts crucial to Judge Hlophe's participation on the 25th of August. The facts that are crucial on Judge Mba's participation are set out from paragraph 137 of the answering affidavit up until paragraph 144 of the answering affidavit. These are the facts at paragraph 137.1. Judge Meyer, the president of the Supreme Court of Appeal, had a conflict of interest in matters relating to Judge Hlophe. How that conflict of interest arose is set out between paragraph 137.1 and 137.3. Firstly, Judge Meyer had declared to former president of the Supreme Court of Appeal, President Howie and President Mpati, that she could not sit in any matter involving Judge Hlophe. So it's a historical matter, not merely out of convenience. Number two, President Meyer has known Judge Hlophe since 1994, when they worked together at the IEC in Umtata. Point three, Judge Meyer and Judge Hlophe taught together in the same law department at the then University of Transkei. Judge Hlophe, in fact, started President Maya's judicial career by persuading her to act as a judge of the High Court when Judge Hlophe was Deputy Judge President. Judge Maya has confirmed this on oath. In relation to Judge Petse, the facts are set out at paragraph 139 to paragraph 140 of the answering affidavit. Here are the basic facts. Judge Petse and Judge Hlophe have known each other for more than 40 years. They first met at Fort Hare. They then reconnected at the University of Natal. They would later meet again in Umtata when Judge Hlophe was a lecturer and Judge Petse was an attorney. They were social friends, and they also had a professional relationship. As a consequence of the social friendship, Judge Petse considered himself conflicted. It was on this basis, which is what is set out at paragraph 142, that Judge Mba was considered appropriate to replace Judge Maya and Judge Petse, who were conflicted from attending the meeting on the 25th of August. Judge Mba had certain attributes about him that lent him to being suitable. One was that he was a senior judge of the Supreme Court of Appeal. The second was that he was also a head of court. Now, those are the bare bones of the facts. Let me turn on to why, on the law, there is nothing untoward in what transpired. The starting point in a case like this is Section 178 of the Constitution itself. It tells us the composition of the Judicial Services Commission. Firstly, what we know about the Judicial Services Commission is that it is a body established directly by the Constitution. It is not one of those that the Constitution says national legislation should be passed. It comprises, we know in 178, 1A and B of the Chief Justice and the President of the Supreme Court of Appeal. And obviously various other constituency-based members. Now, in Section 178, sub 7, it is provided that if the Chief Justice or the President of the Supreme Court of Appeal is temporarily unable to serve on the Commission, the Deputy Chief Justice or the Deputy President of the SCA, as the case may be, acts as his or her alternate on the Commission. There is no provision made for an instance where the Deputy President of the Supreme Court of Appeal is not present. This clause, this Section 178, this section obviously must be read together with the balance of the Constitution. I want to highlight a few aspects. The first one is Section 1C, that says that the South Africa is founded, it is a value, on the value of supremacy of the Constitution and the rule of law. The second is Section 2, that says the Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. In this context, then, one finds Section 165 in the context where South Africa is founded on the rule of law, and in the context where the Constitution is the supreme law and all other laws that are inconsistent with it are invalid to the extent of that inconsistency. Section 165 is then the practical expression of that value because it imposes judicial authority on the courts. But it also expressly provides in Section 165(3) that no person or organ of state may interfere with the functioning of the courts. And in Section 165.4, organs of state through legislative and other measures must assist and protect the courts to ensure the independence, impartiality, dignity, accessibility, and effectiveness of the courts. Courts are also given extraordinary powers by the Constitution. Specifically, under Section 172, they can declare conduct of Parliament and conduct of the President to be unlawful and invalid. And Section 177 is another section that is crucial because it deals with the removal of judges. So when one reads the scheme of the Constitution as a whole, what one gets is a series of interlocking provisions which are designed to protect judicial independence. That protection of judicial independence is protection from internal and external threats to judicial independence. And so when one reads Section 178, one does not do so in a vacuum. One does so in a scheme of the Constitution whose ultimate purpose is to safeguard and protect judicial independence. I want to stress that there is no greater threat to judicial independence than internal threat. If the judiciary is eroded, it is extremely difficult to police and it can be corrosive. There are 4 judgments which have considered the composition of the JSC, both in appointments and in impeachment type proceedings. Let me deal with each one of them, and I'm going to submit at the end of this that the key question that the court must be concerned with is whether the absence of Judge Meyer and Judge Betze was justified on the facts. If it was justified on the facts, it is legally inconsequential that they were subsequently nominated Judge Mba to represent them. The first case is the. Sorry, Judge.
Just to show that I follow your arguments properly. Maybe during your argument, if you can just indicate to me if Judge Betze or Meyer did not authorize or appoint Judge Mba to replace them, would that affect the composition of the JSC? Would it be invalid for them not to, if they did not send another senior judge to the JSC?
Yeah, I will make 2 submissions on that. If the absence did not affect the majority, then the answer is no, it would not affect it. But it was necessary to send Judge Mba, otherwise there would be no majority. But let's first deal with the absence of Judge Betze. How does the law say that absence should be dealt with? The first is the judgment of the Premier Western Cape versus acting chairperson of the JSC. This is the full bench judgment of the Cape High Court. It considered, the court will remember, an instance where the JSC had acquitted Judge Hlophe of charges of gross misconduct based on a recommendation by a 3-member panel. Now, that judgment, we have referred to it in our heads of argument. It's reported in 2010, volume 5, SA 634. It is a judgment of Judge Jones, I think, and Judge Ibrahim. It considered the meeting of the JSC held on the 15th of August, 2009, to consider a complaint against Hlophe, Judge Hlophe. At paragraph 17, which is the crucial paragraph, it notes the rule in Skirot versus union government. The court knows the rule in Skirot. If a statute prescribes specific officers to attend meetings and does not require a quorum, it is presumed that the statute intends that all of those persons mentioned should attend. In paragraph 17, the court deals with that dicta from Skirot and says, the rule is not absolute. Proceedings need not be regarded as a nullity if there are sound reasons for the non-attendance of a member. So that's Skirot and applied on the facts that proceedings need not be regarded as a nullity if there are sound reasons for the non-attendance of a member. In other words, if a member is named in a statute as required to attend or be present, but does not attend because of sound reasons, those proceedings ought not to be regarded as a nullity. On the facts of that case, there was an explanation given, and there were two parties that were crucial that did not attend. The one was the Chief Justice. The second was Advocate Ntsebeza, who did not attend. The finding at paragraph 18 is that the absence of at least one member of the JSC was not satisfactorily explained. This was despite the applicant's invitation to the first and second respondents to give a proper explanation in the fourth affidavit. And the court then says, on the face of it, therefore, the objection is good. So one, according to this judgment, looks at whether there is a proper justification for the absence. In the Supreme Court of Appeal, when the matter, that topic is dealt with at paragraph 21 of the SCA judgment, where the court says, the court a quo also found that the JSC, again on its own version, was not properly constituted, in that one of the practicing advocates to be appointed in terms of section 178(1)(e had not been appointed by the president. Then it says, and this is the crucial part, the point adds little to the previous one, and I prefer to leave it open, especially in view of the fact that it is not known why the advocate had not been appointed. The reason for the omission is not something that necessarily falls within the knowledge of the JSC. So what we have here, which is my second judgment, is that the SCA says we should leave the question open because we don't know what is the justification. And we know that in the context where the High Court has already said it all depends on whether there is a good reason for the absence of the specifically designated member. The third judgment, not in the context of impeachment, but in the context of appointment of judges, is Cape Bar Council versus JSC. It is also referred to in our heads. It is reported in 2012, volume 4, BCLR 406. It is a judgment of Judge Kuhn, which again is also a very learned judgment. It deals with the matter at paragraph 88, the specific principle of the Skirot as applied to a certain set of facts. And then it says this rule was held not to be absolute, and that proceedings would not be regarded as a nullity if there are sound reasons for the non-attendance of a member of such a body. And then it refers to the judgment of Judge Jones that I have referred to earlier. It deals specifically with the facts of that case at paragraph 91. And then it says, although section 178(6) of the Constitution empowers the respondent to determine its own procedure, it has not sought to establish a quorum either in the procedure of commission or elsewhere. When it decides on matters regarding the appointment of judges, it performs a pivotal function in our constitutional dispensation. Then it says, there might be instances where, for sound reasons, non-attendance of a member may not invalidate the proceedings, which need not be dealt with in this judgment. But the present, where no reason was given why the president and the deputy president of the SCA were not able to attend, is not such an instance. Now you remember, in fact, Judge Henley had been shortlisted and recommended to the president for appointment. other judges, including Judge Rogers missed out with 1 vote, but the president of the SCA did not attend, nor did the deputy president of the SCA. And the ultimate finding of the court is, if you do not give a good reason for the non-attendance, we will invalidate the decision. That judgment then went on appeal. This is now the 4th judgment dealing with this topic. It went on appeal to the Supreme Court of Appeal, and in the judgment referred to as Cape Bar Council. And the question, of course, was the examination of the validity of the proceedings of 12th of April 2011, in terms of which Judge Hlophe was the only recommended candidate and the others were not. There are 3 passages that are crucial from that judgment of the SCA, which bear on today's case. The first one is paragraph 27, where the judge, I think it might have been Judge Hlophe, says the following: with regard to the JSC's contention that it is impractical to insist that every meeting must be attended by every member or his or her alternate, I believe that section 178(7) requires a distinction to be drawn between the Chief Justice and the President on the SCA on the one hand, and the rest of the members on the other. And here is the crucial part. But situations which would warrant invocation of the principle expressed by the maxim, lex non cogit ad impossibilia. Everyone knows what that maxim is about. The law does not require the performance of the impossible. Section 178(1)b, read with section 178(7), requires the presence of the Chief Justice and the President of this court or their designated alternates for the valid composition of the JSC. So in that paragraph, the exception given is an exception of lex non cogit ad impossibilia. But let's then look at how this is applied in that case, which is at paragraph 35 of that judgment, how that principle is applied. Paragraph 35, the judge says, acceptance of counsel's argument would mean, for instance, that matters relating to a specific high court could be determined in the absence of the judge president of that court and the premier of the
sorry to interrupt, JP. We are having problems with our internet connection, so I've lost a bit of my learned friend's arguments. Could I just be given 2 minutes to try and resolve the network problem I'm facing? It's completely off. So I'm using my attorney's phone.
So you need 2 minutes to reconnect.
Yeah, I'm just trying to see what's going on, because there's a bad signal. Yeah.
Are you connected now, Mr. Masuk?
Well,
or are you still trying?
I'm trying to see the stability of this network here, because it keeps flashing a green light, which means I'm connected, but it looks unstable. So I'm trying to see whether there's a problem that I can get our IT people to look at.
So we can hear you clearly. The problem is that you cannot hear Mr. Hlophe.
Yeah, well, I'm hearing. Right now I'm using my attorney's phone on my computer, because it's blocked off. But I mean, if needs be, I can use this phone.
Yeah, I would suggest that maybe in the meantime use the phone, because at least you can follow the argument.
That's fine.
And if there's another problem, you can bring that to my attention. Okay. Yes, thank you, Mr. Hlophe. You can proceed.
Thank you. I am at paragraph 35 of the SCA judgment in Cape Bar Council, and this is the 4th of the quartet of the relevant cases. Now, it says, what is more, the judge says in the second sentence, what is more, I believe, it is clear from section 178 of the Constitution that the JSC has been created in a structured and careful manner. And here is the line that's crucial. Its composition obviously sought to ensure that persons from diverse political, social, and cultural backgrounds representing varying interest groups would participate in its deliberations. And then he says any interpretation of Section 178 which would allow decisions of the JSC to be validly taken with the unjustified exclusion of one or more of those interest groups would therefore negate the very essence of the constitutional design. So the key, again, consistent with paragraph 27, is the unjustified exclusion. So when you exclude a person without justification, that results in invalidity. And that is again emphasized at paragraph 36, where the judge says, I therefore agree with the court accords finding that in the absence of the president of this court and his deputy without justification, the JSC was not properly constituted at its meeting with regard to the unsuccessful 6 candidates were therefore not validly taken. So in summary, all of these 4 judgments emphasize the point that if there are valid reasons, if there is a justification, that ought not to be regarded as a nullity. So what are the 5 key takeaways then from these judgments? The first one is that a full complement ought normally to attend. The second is that the failure to attend does not necessarily lead to invalidity. The third one is that the Constitution does not require the performance of the impossible. The fourth one is that any exclusion of a member should be justified. The fifth one is that any absence of a member should be justified. So we come back to where we started on the facts. Was the absence of Judge Zondo explained? The answering affidavit is uncontested on this explanation. Firstly, Judge Zondo was conflicted flowing from his participation as a mediator. The Constitutional Court in the full versus Hlophe case specifically noted that Judge Zondo was one of the judges that were conflicted. In that same passage, Judge Mba, who was an acting judge in the Constitutional Court at the time, was not listed as one of the judges that were conflicted. But the case could not be heard because the judges that ultimately turned out to be conflicted resulted in the lack of quorum at the Constitutional Court. They could not have 8 judges. Judge Zondo's non-participation is also explained because Judge Hlophe had chaired the meeting of the 4th of June 2021, which triggered the deliberations on the 25th of August 2021. So that is a second explanation. Judge Hlophe's participation is also explained because at that point she had been appointed as acting Deputy Chief Justice. And there was an absence of a Deputy Chief Justice because Judge Zondo had become the acting Chief Justice automatically by operation of law. Has Judge Meyer's non-attendance been explained? The paragraphs 137 and 139 of the answering affidavit are uncontested. Those absences have been. Now, let me stress here that it was open to Judge Hlophe to contest the justification of the JSC, but he did not. Instead, he embraced that justification. So it's clear that there is a good reason for the non-attendance of the designated member. It is also clear that there is a good reason for their replacement given on the papers. Now, Judge DJP Ledwaba, you asked me about Judge Mba specifically. Again, this turns on an explanation. It was necessary that there should be somebody sent to the JSC. so that the JSC does not find itself without a quorum. Let's face it. It was necessary that Judge Hlophe should attend. It was necessary that someone from the SCA should attend. If you did not do that, you would have been faced with an incorrect JSC. Now, if I am right, that when you read section 178, you don't do so in a vacuum. You do it in a way that is compatible with the balance of the structure of the Constitution, where one of the core principles is the safeguarding of judicial independence. Then you must ask yourself, should I give an interpretation to the Constitution that ultimately enables the erosion of judicial independence, or should I give a sensible interpretation to the Constitution, which is what all of these other judges that have looked at composition have done? 2 SCA judgments, 2 High Court judgments, all of them give a sensible and a pragmatic interpretation, which is where there is a good explanation for the non-attendance, we do not invalidate on that account alone. What we do, we interrogate the cogency of the explanation. In this case, the cogency is uncontested. It's common cause, it is accepted by both.
Yeah. Advocate Nwagaitobi,
So that we...
Sorry to interrupt you. Is there any allegation in the papers wherein Judge Maya or Deputy President Betze are alleging that they want Judge Mba to be their alternate so that the JSC should correct?
No, there isn't. I'm simply saying, as a matter of logic, it was necessary for him to attend. Otherwise, the JSC would not. In fact, where there is, in fact, what I noted, I must not be too quick to explain that, because there is a note by Mr. Chilo, which is circulated to the other members of the JSC, which actually lists what the roles of each of the members of the JSC are doing there. I must ask my junior to find it. It actually says, it's actually an attendance list which says Judge Hlophe will be there as acting Deputy Chief Justice, and it says Judge Mba will be there, and in that way they can work out the quorum. I'll find that, but there is no allegation in the answering affidavit to that effect. I'm simply making the legal submission on the facts that if you did not nominate, paragraph 142 specifically explains of the answering affidavit, President Maya and Deputy President Betze were unavailable as contemplated in the JSC Act. It was accordingly appropriate and necessary to appoint a senior justice of the Supreme Court of Appeal to represent the Supreme Court of Appeal at the meeting considering the tribunal's report. Justice Mba was the most senior justice available to sit at the JSC meetings on behalf of the Supreme Court of Appeal. Justice Mba is also a head of court. Justice Mba was thus appointed to represent the Supreme Court of Appeal by President Maya, acting with the concurrence of Deputy President Betze. Oh yes, in fact, I'm wrong, Justice Ledwaba. I knew that I was being too quick because I'd seen this. Paragraph 143 says, to suggest that Justice Mba could not attend not only undermines the spirit of the JSC Act, but creates an absurdity in that the JSC would lack quorum should any head of court be unavailable for whatever reason. This is why powers can be delegated. Justice Mba was lawfully delegated to represent the Supreme Court of Appeal at the JSC as per the composition of the JSC. So I was wrong in the answer I gave you. It's actually expressly pleaded.
Yeah. Is it a fact that even if Justice Hlophe, if we find that Justice Hlophe sitting there was justified, is it a fact that if Justice Mba was not there, then they would not form a quorum?
I will have to look at that closely, but at the time, and that's the point I'm simply making, at the time of the secondment of Judge Mba to the JSC, one of the considerations that are pleaded is the issue of quorum. Because what you would then have, you would not have the president of the SCA, you would not have the deputy president of the SCA, you would also have no one representing that court and that would impact on the quorum. So that the only point I make is that it was a perfectly logical and justifiable factor to take into account, that if we don't send someone, there might be a criticism of quorum.
Okay.
Mr. Nkatobi, can I ask you this? You've touched on delegation and you've taken us through the legal framework. Is there anything else in the Constitution where we can find an implied delegation?
No, I have not seen that in Section 178.
Section 238 just is the executive that can delegate.
Yes, yes.
But it can't be read into the framework that you've outlined.
No, not in this framework.
Delegation.
No, not in this framework. I mean, basically, this is the position here, is that the decision is taken at the level of the SCA, that Judge Mba should attend, because neither Judge Maya nor Judge Petse can attend. He's seconded to represent the SCA for good reasons. And that's the focus that we are urging the court to look at, whether good reasons or not. So I argue that the first one, the conflict of interest, is a good reason that has not been contested. Secondly, the fear about the absence of quorum was a legitimate reason to be taken into account. And those two suffice to meet the threshold that is required in these judgments. I mean, the one talks about unjustified exclusion. The other talks about unjustified absence. The other talks about a good reason to be given. All of them ultimately say that you have to give practical sense to the Constitution. The Constitution exists to serve a purpose, and the purpose in this instance, I say, is the preservation of judicial independence. So I argue, with respect, that if you look at the structure of the Constitution, you look at the reasons that are given, and you look at the judgments that have been cited. Our learned friends have been too quick to say that the Cape Bar Council and the Premier Western Cape judgments are decisive on the point, but they forgot the detail. All of those judgments ultimately depend on whether there is a good explanation or not. I want to move then to my last heading on this, which is the argument of Judge Hlophe is absurd.
Can I interrupt you before you move on to your next point, Mr. Nkatobi?
Thank you, to JP.
On the basis of the proposition you advance, it must follow that you say, in the absence of Judge Mba, the JSC would be paralyzed and unable to make a decision.
Yes, yes.
Is there no other way to avoid the paralysis other than the one that you've put forward, that the Deputy President of the SCA could nominate a suitable delegatee?
Yes, there are two options. In fact, you put this yesterday, Justice Sutherland, to our learned colleague. There are two options, both of them are stuck. The one option is that you attend the meeting despite your conflict of interest. But we know that Judge Hlophe would challenge that as well. The other option is that you embrace your conflict of interest and you appoint a suitable delegatee. Now, between those two, you have to think about which one is compatible with the scheme of the Constitution as a whole. We know in the case of Full versus Hlophe, all of the judges of the Constitutional Court who were in that case decided there was no quorum because of the conflict of interest. So at that highest level, the judges do not say we must sit out of necessity. They say we are conflicted, we must recuse ourselves. The consequence of that is that the leave to appeal is dismissed. And that is a similar scenario to what we have here, which is the judges embrace their conflict. They don't attend the meeting and they appoint a suitable delegatee. Now, those are the two practical mechanisms of ensuring the fulfillment of the scheme of the Constitution. Otherwise, you have a strange scenario in which the JCT report just lives in limbo. It's never considered at all. But this is the absurdity, in my last part of the argument. Where do we go from Judge Hlophe's reasoning in the matter? We know that he is happy that Judge Meyer and Judge Betze were conflicted and didn't attend. He embraces that. He has no difficulty with that. But he does not want Judge Mba to have been present. We also know that he does not want Judge Kampempe to have been present. And where do we go with those outcomes? We come to an absurd outcome, utterly absurd outcome, that a judge who has been found guilty by the JCT of having committed one of the most serious possible breaches. He violated Section 165, which is the section that says the judges must uphold judicial independence. The absurdity arises because, according to him, we are in a state of complete paralysis. But it is a state of paralysis that he has manufactured. Because you remember that when the Constitutional Court had the full case, which is fairly recent, 2018 or 2017, it is where virtually each and every judge of the Constitutional Court and many judges of the SCA and many judges of the High Court are contaminated, because at every turn someone else is implicated. The three of you are now implicated. So we are in a situation where, through the sheer lethargy of the JSC and the constant litigation, virtually all the judges will potentially be said to be conflicted. Judge Hlophe's case would simply never be dealt with at all by the JSC. Now, you have to ask yourself if such an absurd outcome is contemplated within the scheme of the Constitution. If you take the view that such an absurd outcome is not contemplated within the scheme of the Constitution, the real question is one of interpretation. What is a sensible way of dealing with a scenario which is not regulated expressly by the Constitution? The situation of justified or explained absence of a designated member. In the judgments that have come before you, 2 SCA judgments, 2 full court judgments, it has been said a justified absence will not invalidate the non-attendance of a member. But in this case, a nominee was necessary in these circumstances in order to fulfill the foundational aspects of the Constitution itself. So we say that once you actually take a step back and you reflect on what Judge Hlophe wants, it is impossible but to come to one conclusion, that these absurd outcomes that he contends for are also self-serving. What he is gunning for is a regime in which he is immunized from taking the consequences of his action. I listened to my learned friend yesterday about what he says actually should have happened. I came to the one conclusion that what we are dealing with here is that, and there was a lot of criticism against the JSC about delays, but what we are ultimately dealing with is that this delay is now being used for selfish reasons, is being exploited in order to avoid accountability. So I agree with my learned friend that given the passage of the time, it is now time that the matter should be put to bed. What that means is that the JSC has performed its function. It has decided that Judge Hlophe's conduct is impeachable. The matter now must go to the politicians. They must decide whether or not Judge Hlophe should be removed. He has no basis in the matter of the JSC system. That takes me to the issue of remedy. And I'm only dealing with remedy only in the context of composition. Mr. Maleka will deal with remedy in the context of the merits of the case. If, despite what I've submitted to your lordships and your ladyship, you come to the conclusion that there was a problem with the composition of the JSC. You must remember the provisions of Section 172 of the Constitution. You are entitled to declare law or conduct as inconsistent with the Constitution, but you are also entitled not to set aside. Let's go to that section again, because it is a very powerful mechanism of exercising judicial power in difficult cases. In Section 172(1)(a), when deciding a constitutional matter within its power, a court must declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency. So in this case, we are not dealing with a law but conduct. So the conduct theoretically could be declared to be invalid and unconstitutional. But under B, you may then make an order that is just and equitable, including an order limiting the retrospective effect of the declaration of invalidity and an order suspending the declaration of invalidity for any period and on only conditions to allow the competent authority to correct the defect. What that means is that you have wide and untrammeled powers to make an order that, in your view, is just and equitable. So even if you were to declare the meeting of the 25th of August, 2021 as unconstitutional, justice and equity would require that you preserve the outcome, because you don't have to set aside the outcome. Justice and equity would require you to say, we say that it is unlawful, but we are not setting aside the decision. And that would be a just and equitable order. There are many reasons why that is a just and equitable order. The first one is delay. We are at common ground with our learned friends that the delay in this case means that it is time to grasp the nettle, put this matter to bed. The second one is the consequences for public confidence in the system of adjudication. Judge Hlophe does not have a valid defense to the charge of gross misconduct against him. Let's be frank about that. He does not have a valid defense to the charge of gross misconduct against him. And you saw yesterday how a party that purports to support him runs an argument that is fundamentally in conflict with his own argument. He says he is not guilty. The BLA that supports him says he is guilty, just of a lesser charge. But all of this shows that he does not have a valid defense to the charge against him. And thirdly, the finding of the JCT has not been credibly attacked. It is a thorough and a learned exposition of the facts and the law.
Mr. Toby, if I heard you correctly, you said the BLA that runs with Judge Hlophe.
No, I'm not saying it says. I'm saying it purports to support his argument.
But it's here as an amicus. It's here to assist the court, not to support this argument.
No, but it does. The argument yesterday supported Judge Hlophe. Let's be fair about that. The argument yesterday supported Judge Hlophe insofar as they said he did not commit gross misconduct.
Okay, let's leave it there.
So I'm saying even the BLA that runs an argument purportedly in support of Judge Hlophe says that he is guilty of misconduct.
Okay, now I hear your point.
Yes.
You can continue.
Mr. Mandlakayise, what do you say about remittal? Because will remittal not result in the same scenario as we have now on composition?
No, remittal is out of the question. And that is why the only outcome is you can declare this decision to be invalid and refuse to set it aside. And remittal is out of the question because remittal simply conduces to the state of paralysis that Justice Sutherland alluded to earlier. Remittal is totally out of the question. If you remitted this, you would be contributing to a continued erosion of judicial independence and the damage to the public standing and confidence of the judges. And the only remedy that would be appropriate if you were concerned about the composition would be we declare it to be invalid, but we preserve the decision. It is not. So that's why we say what is just and equitable there is that you must leave the decision intact. It's time for the matter to go to the politicians. Let them decide if Judge Hlophe should be removed as a judge or not. The judges have done their job. The JSC has done its job. The sole mistake, which is the attendance of Judge Mba, cannot now undo all of this work that has been done up until now. That is neither just nor equitable. What it does is to reward conduct that has been found rightly by Judge Hlophe and his panel to be inimical to Section 165 of the Constitution. It does nothing to promote the proper administration of justice.
You talk about an erosion. Is that a rule of law issue?
It's been expressly found by the Judge Hlophe panel, expressly found. What they have said here at paragraph 123, in conclusion, on an objective and proper consideration of the facts and probabilities, we find that Judge Hlophe breached the provisions of Section 165 of the Constitution, in that he improperly attempted to influence the two justices of the Constitutional Court to violate their oath of office. B, his conduct seriously threatened and interfered with the independence, impartiality, dignity, and effectiveness of the Constitutional Court. C, his conduct threatened public confidence in the judicial system. If you do not grasp the nettle now, you will contribute to the precise concern of the erosion of public confidence in the judicial system. Deputy Judge President Ledwaba, thank you for the time. I have nothing productive to add.
Okay, thank you. DJP Sutherland, anything?
Nothing. Thank you.
Okay.
I'm told by my junior that there is a risk that if the case is remitted, Judge Hlophe would seek the recusal of all members who voted against him. But that's not me saying that, it's my junior. He's probably onto something.
Thank you very much, Advocate Mwalagai Toby. I see it's now 11 o'clock. Maybe should we adjourn now for 15 minutes? I think that would be ideal so that Advocate Malega can continue with his argument. So let's adjourn and then we'll resume at 11:15. Thank you.
because
Yes.
we are on the same side of the debate.
Yes.
What I propose to do, Justice Hlophe, is to respond to the oral submissions made on behalf of the JP and the BLA without repeating our heads, because I take them as read.
Yes.
I propose to address three main responding submissions. The first would focus on the contention on behalf of the JP that the JSC has not applied the correct law to the evidence, and therefore its decision was not only unlawful, but irrational and unreasonable. You would recall that the BLA make a slightly different argument, and the BLA suggests that on the evidence which is common cause, there cannot be a finding of gross misconduct in terms of section 1771A of the Constitution. At best, there may be a finding of misconduct. For that reason, you should not only set aside the majority decision of the JSC, but remit the matter to the JSC for reconsideration, third round again. The second part of the proposition I'll make would relate to the suggestion that the JSC incorrectly applied a wrong standard. You will recall that the main focus of the JP's contention is that there is not an ethical standard known within the judiciary that judges should not discuss with one another matters relating to judgments pending before them. I would indicate upfront that the contention has materially evolved from what it was before the JCT. You would recall that before the JCT, the contention was not whether or not there was such an ethical rule. The contention was simply that the JP was not aware of it. But I'll deal with the contention on both scores. I will show that as a matter of fact and law, there exists such an ethical rule. But secondly, by his own admission, the JP acknowledges the existence of that rule, albeit in a different context. The last of the oral responding submissions I will make relate to the findings made by the tribunal, considered by the collective whole of the JSC, and supported by the majority judgment. And I will make the point in that regard that those findings of fact by the JSC and their acceptance by the majority decision of the JSC are justified and reflect findings of fact on which this court may not properly interfere in the light of the fact that we are dealing with a case of review and not an appeal case. And in that regard, we will ask the court to show due deference to those findings of fact. Before I get to those three major topics, may I indicate that there are some few others contention that I'd like to dispose of with quite quickly. The first is the case of bias, alleged mainly against Justice Mlambo. Again, there, the case of the JP has materially shifted. You would recall that Justice Mlambo, right from the beginning, when the report of the JCT was presented to the JSC, openly disclosed that he was part of the appeal panel that set aside the judgment of the full bench of this court in Langa v. Hlophe number 1. It was just a disclosure that he made in good conscience, not to suggest at all that he was either conflicted or was biased. And the secretary of the commission did what one would ordinarily expect of a secretary befitting the office of the JSC. He circulated the disclosure of Justice Mlambo to all concerned, including the JP himself, of course acting on the instructions of the Chief Justice. And the Chief Justice invited all concerned to make representation to that disclosure. We now know from the correspondence which is before this court that the response of the JP was not to object to the participation of Justice Mlambo on the basis either that he was conflicted or was biased, but simply to say that he leaves it to the conscience of Justice Mlambo, because there is always a presumption of integrity and independence or relating to each and every judge and a member of the judicial. So that was the high watermark of the JP's response to the disclosure. There was no suggestion, as is now made in the present proceedings, that Justice Mlambo was automatically disqualified or suffered from incurable conflict of interest. We would therefore submit that the new case now sought to be made does not fit quite properly within the facts, and we would ask the court simply to reject the contention of the facts. But in any event, as a matter of law, we have addressed submission to show that Justice Mlambo was not conflicted, nor was he biased. The next issue that I'd like to fairly dispose of quite quickly is the challenge to the mandate of the JCT. You would recall that our learned friends for the JP made some forceful submission that the mandate of the tribunal was fixed by the instruments of its terms of reference, and that in the course of its investigation and the findings it made, the JCT strayed from that mandate. With the greatest of respect to our learned friends, we would submit that although the terms of reference reflected upon the mandate of the tribunal, the true mandate of the tribunal, legally speaking, is fixed and determined by the JSC Act. I would ask the court to make note of the provisions of section 26(2). Well, in fact, it's 26(1) of the JSC Act, which by law and by statute fixes the mandate of the tribunal. It says the object of the tribunals are A, to inquire into allegations of incapacity, gross incompetence, or gross misconduct against the judge as contemplated in section 177 of the Constitution by doing things mentioned in subparagraph 1 to 4. So that is a broad mandate of the JCT. The tribunal, through the terms of reference, was merely required to give content to that mandate on the facts that gave rise to the complaint against the JP. I will get to the terms of reference, and I will show in that regard that even on the assumption of the correctness of the proposition made on behalf of the JP, the tribunal did not stray beyond the mandate. The next point I'd like to deal with quite quickly relates to the allegations of inordinate or improper delay. It is not clear to us what was the final stance of the submissions made on behalf of the JP in that regard, arising from the complaint of delay. You would recall that in the papers, the point of delay was articulated around and pivoted on the provisions of section 237 of the Constitution, which imposes a constitutional duty on all organs of state to fulfill their constitutional responsibilities diligently and without delay. If the point of raising delay was that the JP did not receive proper hearing in relation to the processes relating to the investigation of his conduct, we respectfully submit that that question, which is one of fact and law, has been determined by the tribunal itself, because it's an objection which was raised before the tribunal, and the tribunal dealt with it. I will ask the court to consider the following references, and I believe that my junior will conveniently take the court to that reference as I mentioned them. The first is 008-2370. And it is paragraph 76 of the tribunal's decision. You will see that under that heading of delay, the tribunal engages with objection from paragraph 76, and it makes its conclusion in paragraph 77 on the delay, concluded as follows. We have set out in some detail the reason for the delay, some, if not in no small measure, attributable to the Judge President Hlophe himself. In paras 13, 14, 15, 19, and 27, we have chronicled his own litigation and occasions on which he sought postponement of the proceedings of this tribunal. All these contributed to the delay. It is opportunistic and untenable for Judge President Hlophe under circumstances to advance delay as a basis for prejudice. We would submit that that finding is correct on the facts, and we go further and suggest that the delay, if any, on the part of the JSC was not inordinate. The court knows the history of litigation, not initiated by the JSC itself, but by third parties over which it has no control, which contribute to this delay of 13 years. For its part, the majority of the JSC dealt with the question of delay and adopted and endorsed the conclusions of the tribunal. The court will find the decision of the majority on that score at case line 008-5580 from paragraph 28 to paragraph 31. We would therefore that if ever there was a debate around the effect of the alleged inordinate delay, that debate has finally and properly been resolved by the tribunal and the majority of the JSC. There is nothing irrational or unreasonable about their conclusions in that regard. But if the question of delay was raised in order to suggest that Judge Hlophe has been denied the basic rules of fair trial, and therefore he cannot, before the JSC or before this court, enjoy a measure of fair litigation, we submit that the remedy lies elsewhere. This court knows that whenever the question of delay is raised, impacting on the rights of fair trial, the appropriate remedy is one of stay. There is no application for stay in that regard. May I now turn to our response to the submissions made on behalf of the JP and the BLA on the fact that the conduct at issue before this court merely related to an attempt, but not an actual influence or interference with the workings of the Constitutional Court, namely through Judge Nkabinde and Judge Jafta. We would submit that the fundamental problem of that contention is to misunderstand the true nature of the complaint that the judges of the Constitutional Court lodged with the JSC against the JP. The complaint was not that, as a matter of fact, the alleged interference or influence did, as a fact, interfere with the processes of the Constitutional Court relating to the pending judgment. The complaint was always focused on and limited to an attempt of improper interference. May I give the court the following reference, where the true nature, scope, and boundary of the complaint will be seen. It is the originating document of the complaint itself at 001-493, paragraph 1. You will also go to page 001-494, paragraph 7 and 8. And all of those paragraphs talk about an attempt to improperly influence the processes and proceedings of the court. They do not talk about the success of that attempt. That is how the JSC, when it was directed by the SCA in 2012 to reconsider the matter, understood the complaint, and that is how the JSC itself formulated on the facts the mandate of the tribunal. May I ask the court to reflect on the formulation of the terms of reference guiding the tribunal as to the fact of the complaint before it and how it should approach it. You will find the terms of reference as Annexure JSC2 of the JSC's opposing affidavit. They begin at 012-85, and the purpose of the terms of reference are set out in paragraph 3. And the court will see there that the JSC defined the purpose of the tribunal as follows, and I pick up from the second sentence in paragraph 3. The essence of the complaint is that the respondent approached Justices B. Nkabinde and C. and Jafta of the Constitutional Court and attempted to improperly influence their decision in 4 matters pending. So always about an improper attempt. Then the mandate is defined in paragraph 5 of the terms of reference at 012-86. The tribunal shall investigate and make findings and report on 5.1 whether the respondent attempted to influence improperly Justices B. E. Nkabinde and C. and Jafta. 5.2, if so, whether the respondent is guilty of gross misconduct as contemplated in section 177 of the Constitution. I emphasize paragraph 5.2 because it occurs to us that our learned friends for the JP sought to suggest that it was not part of the tribunal's mandate to make a finding on whether or not the JP was guilty of gross misconduct. Well, we would submit that paragraph 5.2 answers that contention in the facts. And of importance is that the tribunal itself understood its mandate in that way. And I ask the court to consider the findings of the tribunal at 008-2388, paragraph 123. I'm not going to read that part of the tribunal's finding because Mr. Mandlakayise has read it, and I believe that my learned friend, Mr. Marcus, will also deal with it in the light of the submissions that he has made. But the finding is quite clear. It falls within the terms of reference in paragraph 5.2. We would therefore submit that as a starting point, the contention of the JP and the contention of the BLA misunderstood the true nature and scope of the complaint by the judges of the Constitutional Court. We then deal with their submission that on the evidence before the tribunal, there was no case that required a lawful engagement of Section 177 of the Constitution, because Justices Nkabinde and Jafta confessedly made it known to the tribunal that they did not suggest that they were improperly influenced as a fact by the JP. You would recall that our learned friends for the JP referenced the change of statement previously made jointly by the judges of the Constitutional Court on the basis that it did not accurately reflect the true version that they wanted to place before the tribunal. I believe that the more time-efficient way to deal with the contention of the facts is to refer to the tribunal's decision itself, because it accurately records what happened before it when Justices Nkabinde and Justices Jafta testified. And I would ask the court to go to that part of the tribunal's decision, which is, I think it starts after the heading evidence. Let me make sure that it is at case line 008 2355. And the court will see that on that page of case line, there is paragraph 9B and 9C. And 9C read, in the course of that conversation, Hlophe JP sought improperly to persuade Jafta AJ to decide the Zuma/Tin case in a manner favorable to Mr. J.G. Zuma. That was the original version in the complaint. That version was changed before Justice Jafta testified. And the change the court will see somewhere immediately below paragraph 48, and the court will see that in paragraph 48, the following is recorded. The first paragraph referred to the meeting between Hlophe J and Jafta AJ. It was proposed by counsel from Nkabinde and Jafta AJ that the following details should be included in the statement. And the statement in code is, in the course of that conversation, Hlophe JP said that the case against Mr. J.G. Zuma should be looked at properly, or words to that effect, and added, Sitembele Kinina, a rough translation, which is your last quote. So that was the correction. It is understandable why Justice Jafta made that correction, because he made it clear in the course of his testimony that he stopped the conversation between himself and Judge Hlophe because he feared that were it to go further onto the facts, he might have been influenced to see things one way or the other. But he made it quite clear that he was not influenced by that conversation between him and Judge President. Then the next part of the correction the court will see on the same page is with reference to paragraph 10C. And the original 10C read as follows. In the course of that conversation, Hlophe JP sought improperly to persuade Nkabinde J to decide the Zuma/Tin cases in a manner favorable to Mr. J.G. Zuma. Then Justice Nkabinde corrected that earlier version. The correction is to be found in paragraph 49 at the foot of the page. It reads as follows. The second paragraph referred to the meeting between Hlophe JP and Kabinde J. It was proposed by counsel from Kabinde J and Jafta AJ that the following details be included in the statement. In quote, in the course of that conversation, Hlophe JP said he wanted to talk about the question of privilege, which in his words formed the gravamen of the National Prosecuting Authority's case against Mr. J.G. Zuma. He further said the manner in which the case was to be decided was very important as there was no case against Mr. Zuma without the privileged information, and that Mr. Zuma was being persecuted just like him, in parenthesis, Hlophe JP, had also been. So that was the correction. And the tribunal correctly record the effective consequences of the two corrections in paragraph 32 of its judgment at case line 008-2356. And the tribunal made it quite clear that the judge's consent ought not to be condemned by the correction of their version. Far from it. It is commendable what they did, because they did not want to advance a version that was inconsistent with their own recollection. But secondly, they did not want to express an opinion on the matter that was finally within the remit of the tribunal's decision and mandate. Whether or not the attempts alleged were inconsistent with judicial ethics was a matter that the tribunal had to decide, and not the judges themselves. Their job as witnesses was to give the evidence, and where there was some discomfort on their part with regards to an earlier version they put as part of the original complaint, they were entitled to correct it, as they did, and commendably so we submit. Our learned friend suggests that the change of version meant that there cannot be any case of gross misconduct under section 1771, because on the version of Kabinde J and on the version of Jafta AJ as it then was, the attempts were not successful. And on that basis, you cannot find that the JSC correctly concluded that there was a case of gross misconduct. So the sum total of their submissions, as we understand it, they suggest that a case of an attempt, improper influence or interference cannot properly trigger the machinery of section 1771 of the Constitution. And of course, I accept that the BLA makes a slightly different case on the engagement which our learned friends for the BLA had with the court. He suggested that that type of the attempt, if it did not succeed, then it can give rise to a case of misconduct of the ordinary nature, and not one which is gross. So in the final analysis, our learned friends seek to draw a distinction between an attempt at improper influence that succeeded, which on the version, if it succeeded, will give rise to a case of gross misconduct on the one hand, and an improper attempt of interference or influence which did not succeed. On the version or on the contention of the JP, we know that that latter part of the case will not give rise to any misconduct at all. But we now know on the submission of the BLA, that type of attempted interference may possibly give rise to a case of misconduct of the ordinary kind. We would respectfully submit that their submission is so fundamentally mistaken, at least at 3 levels. And we would like to explore those 3 levels. The first is that the distinction of an unsuccessful and a successful attempt at improper influence posits a lower standard of judicial ethics in circumstances where the majority of the JSC itself has posited a high standard of judicial ethics. May I give the court references where the JSC by majority upheld that standard of high ethics? I ask the court to go to 008-5596, and there the court will find paragraph 66.3. And the majority held in paragraph 66.3, the public is entitled to require senior judges in the judicial system to adhere to a high standard of impartiality and independence. That is a high standard posited by the majority of the JSC itself. And yet the contentions of our learned friends for the JP and the BNA posits a fundamentally lower standard. There is no reason why judges in our judiciary should not be held to a high standard of the kind the majority posited. And by the way, Justice Sutherland, the minority of the JSC, which considered the report of the tribunal, never engaged with that part of the majority decision. They never suggested that that part of the majority decision was mistaken at all. We nevertheless submit that the high standard posited by the majority of the JSC is correct and properly directed at vindicating not only the code of conduct governing the ethical standards and norms of the judges, but also it vindicates the Bangalore principles which the code invokes as an international standard of application to judicial conduct. I ask the court to take into account the following parts of the code because I'm told that the code has not been uploaded on Caseline. It is paragraph 7 of the preamble and the notes. If the court has the code itself, the court will see that the code itself starts with a preamble. And the preamble in paragraph 7 says it is necessary for public acceptance of its authority and integrity in order to fulfill its constitutional obligations, that the judiciary should conform to the ethical standards that are internationally generally accepted, more particularly as set out in the Bangalore Principles of Judicial Conduct of 2001, revised at The Hague in 2002. I asked the court to take the following references because they talk to that high ethical standard. Is note 5.1 and note 5.2 explaining the import of Article 5. And note 5.1 reads as follows: a judge behaves in his or her professional and private life in a manner that enhances public trust in or respect for the judiciary and judicial system. A judge avoids impropriety and the appearance of impropriety in all judges' activities. And the last that we would ask the court to consider is note number 2, explaining the import of Article 11. Private consultations and debate between judges are necessary for judicial for the judiciary to perform its function. However, these occasions may not be used to influence a judge as to how a particular case should be decided. And of course, the Bangalore principles themselves speak to this in Part 2, Article 10.1, Sub-Article D. And it says that in decision-making processes, judges are able to act without any restriction, improper influence, inducement, pressure, threat, or interference, direct or indirect, and I emphasize this qualification, direct or indirect, from any quarter or for any reason, and exercise unfettered freedom to decide cases impartially. We respectfully submit that that qualification of direct or indirect covers actual or attempted interferences that are improper, because we know that interference may take different forms. They may be direct or they may be indirect. And frankly, all of these standards are consistent with the oath that judges take at the performance of their judicial functions and duties, and that is to do justice between man and men, and man and the state, without fear, favor, or prejudice. And so we submit that on any front whatsoever, the high standard of judicial ethics adopted by the majority of the JSC is one which this court must uphold. The distinction by our learned friends to suggest that an attempt which is not successful cannot trigger the application of Section 1771 of the Constitution is mistaken, because it is based on a low standard of judicial ethics and probity. But there is a more decisive answer to our learned friends' attempt to make a distinction between a successful and an unsuccessful attempt. And that is the fact that their propositions in that regard suffer from serious jurisprudential deficit in two ways. The first is that it propounds an inflexible rule on when Section 1771A may be triggered in circumstances where the mandate of the JSC to decide when those provisions may be invoked is formulated in the broadest, widest amplitude. It is formulated in a manner which the drafters of the Constitution did not even seek to guide the JSC about what constitutes gross misconduct. They left that decision to the JSC. They left it also to the JSC initially to decide how it should engage in that exercise. We now know that the broader mandate conferred upon by the JSC has now been refined somewhat in terms of the JSC Act. But even in the refinement that was brought about by the 2008 amendment, the Act itself did not even limit that broad mandate of the JSC by defining what constitutes gross misconduct. All that the Act did in Section 14.3 was to define what are the basis of a lawful complaint against a judge that would merit investigation by the JSC through the tribunal. I ask the court in that regard to have consideration of the provisions of Section 14.3 of the Act. The court will see that All that the Act says in that regard is to provide that a complaint must be based on one or more of the grounds referred to in subsection 4. And those grounds are mentioned. And one of the grounds mentioned is the very ground of gross misconduct in subsection 4A of section 14. And again, that section does not cross references to any definition of gross misconduct. We would submit that the broad mandate of the JSC set out in section 177 of the Constitution and refined in section 14, 3 and 4 of the JSC Act is designed to provide a flexible standard for obvious and understandable reasons, because gross misconduct may come in different ways. It would have been ill-advisable for the lawmaker to try and limit the remit of gross misconduct without knowing generally how it would arise. And we therefore submit that this court should give content to that broad standard by upholding a flexible approach and not an inflexible approach of the kind suggested by our learned friends. You would recall that for their part, our learned friends for the BLA referred the court to the Mwepe report. The report was made by J.P. Mwepe when he was part of the three-man committee of the JSC, which was tasked to guide the JSC in the first round of its investigation of the complaint. And you would recall, JP, that there was a set of two reports. The one was by the minority, and that is Justice Mwepe's report, and the other was by majority, which was formulated by our learned colleague, Mr. Vasoni and Mr. Seminya. And they asked the court to consider a passage in that report. The court will find it at case lines 001, 111. And our learned friends referred in that regard to paragraph 30, where Justice Mwepe grappled with the difference between interference and influence. And you would recall that our learned friends for the BLA pressed upon the court to accept that elucidation by Justice Mwepe because on their research, they did not find any judgment of a court in this titanic historic battle in litigation, which rejected that analysis. We take what our learned friends for the BLA said to this court at face value, but we submit that what they have referenced on this score is paragraph 30, when the key parts of the Mwepe report, which answers the flexible approach to the mandate of the JSC, is paragraphs 28 and 29. And with your leave, His Lordship presiding, I would ask for permission to read these because they are fundamental to our submissions. In paragraph 28, the Mwepe JP report noted the following. The Constitution does not define gross misconduct. The word gross qualifying misconduct is not a term of art, nor does it convey consistent meaning in all circumstances. It depends for its meaning on the context and the facts of a particular circumstance. However, the dictionary meaning of flagrant, blatant, glaring, serious, major, significant, etc., as opposed to minor, give an indication of the gravity that the conduct has to exhibit before it can be referred to as gross. I skip the rest. I go to paragraph 29. The power to make findings of judicial misconduct is vested in the Commission, It is accordingly the responsibility of the JSC to assess evidence in support of the complaint and counter-complaint in order to determine if any of the judges is guilty of gross misconduct. Then it goes to assess the rest. But the point which JP Hlophe made, rightly so we submit, is that you cannot look at gross misconduct in the air and formulate inflexible standard without regard to the particular facts and circumstances of each case. We rely on that part of the report, which on the analysis of the BLA has not been questioned in any judgment of this or other appellate courts in support of a proposition that the standard they pose is far too inflexible and this court should reject it.
Mr. Malika, are you saying that a dictionary definition doesn't assist?
It does
influence or interference.
It does assist, but simply to guide on the degree of influence that can qualify as gross or not. But you cannot make a finding simply based on the dictionary meaning. You have to look at the facts and circumstances of each case in order to determine whether or not, in line with the dictionary meaning, it's worse or egregious. Thank you, Justice Victor. But there is a more jurisprudential deficit in Leonard Friend's submission. And it is the fact that it is at odds, the standard they propound of gross misconduct by way of a successful or unsuccessful attempt is at odds with at least two judgments of the Constitutional Court. We ask the court to reflect on the decision of the majority of the JSC because that decision engages with that standard with reference to the two decisions of the Constitutional Court. Ask the court to go to 008-5586. And on that page of case line, the court will see that there is paragraph 41, 42, and 43. I skip paragraph 41, I emphasize paragraph 42. And there the majority held the following. At the core of judicial independence is the, and in parentheses, complete liberty of individual judges to hear and decide cases that come before them. No outsider, be it government, pressure group, individual, or even another judge, should interfere. And here comes the rub for the BLA and the JP. In fact, or in attempt to interfere with the way which a judge conducts his or her case and makes his or her decision. You will see that the majority of the JSC decision references a judgment of the Canadian Supreme Court in the Queen versus Beauregard. That is the dictum lifted from that judgment of the Canadian Supreme Court, but was cited with approval in the following two cases of the Constitutional Court. The first is the DeLange case, which footnote 56 of the majority references, and you will see that it refers to paragraph 70. The court will see when the court looks at that part of the DeLange judgment that that code is from that is approved by the Constitutional Court in paragraph 70 of the DeLange judgment. The second is Van Rooyen and others versus the state and others. And the citation is given, and it is paragraph 19 of the judgment of the Constitutional Court. Again, approving the dictum in Beauregard. The fundamental point is that the Constitutional Court made it quite plain that it is not the successful interference as a fact, but an attempt to interfere which would impact on the standard of judicial independence. But closer to the facts of the current and present complaint is what the SCA itself held in the judgment cited by the majority of the JSC in paragraph 43 of its decision. And you will see that in paragraph 43 of its decision, the majority cites the case of freedom under law, and it's a judgment of the SCA, whose full citation is given in footnote 57, where the SCA said any attempt by an outsider to improperly influence a pending judgment of a court constitutes a threat to the independence, impartiality, dignity, and effectiveness of that court. So that we would submit that the majority rightly held that the standard it has to apply includes not only an interference which succeeded as a fact, but interference which did not succeed but was an attempt. And again, Justice Sutherland, it is quite curious that the minority has not even reflected on this part of the majority decision of the JSC. The minority report is simply silent in that regard. And we would be surprised if our learned friends for the JP still persist that the minority got it right and the majority got it wrong. We therefore submit that the distinction our learned friends seek to draw is at odds with established principles. And the third basis on which we differ with our learned friends is that the standard they posit places emphasis at the wrong end of the inquiry contemplated in section 1771, because it suggests that if an attempt is unsuccessful, it won't constitute gross misconduct. It therefore requires an investigation into the response by the targeted judge in order to determine whether the conduct of an offending judge constitutes gross misconduct. We would submit that that type of distinction is absurd in the extreme, because it means that whether the conduct of a particular judge constitutes gross misconduct or not, it depends on the attitude of a targeted judge. And so, for instance, take an example that we all work with in these proceedings. An offending judge offers a bribe to a targeted judge to decide a case one way or the other. Or he offers some sort of benefit to the judge concerned, whether it's one of promise for higher judicial office in a case involving an appointing authority. A judge who is principled will reject that offer. On the approach of our learned friends for the BLA and the JP, it means that because a principled judge has rejected that offer, there cannot be any justification for invoking section 1771 because a principled judge rejected the offer. Take the same fact and the targeted judge succumbed to the temptation to accept the offer. On our learned friends' contention, it means that the offending judge would rightly become a subject matter of an inquiry under section 1771. Yet the conduct is the same. In one instance, it succeeded, in the other, it did not succeed because of a judge who decided to uphold his or her integrity and independence. We would submit that to place emphasis on the wrong end of the inquiry does not make sense at all. There is no explanation by learned friends for the BLA. Why should one draw such arbitrary distinction, which is dependent on the success or failure of an attempt to influence?
Mr. Mandlakayise, what do you say about the presumption of judicial integrity, the argument that was submitted yesterday?
I'll get to it, but let me answer it now quite quickly, and I'll elaborate on it when I get there on the facts. And our learned friends make it quite clear in their own formulation that is a presumption. Like all other presumption, it may be displaced by evidence. And where the evidence as we submit in this case justifies the displacement of that evidence, of that presumption, it can no longer apply. We do not understand our learned friends to suggest that the legal status of that presumption, such as it may be, it's intractable and therefore cannot be displaced by the evidence. From their approach, it's a presumption which we submit can be rebutted by evidence. But secondly, the presumption, such as it may exist, and we're going to connect the contention on the presumption together with the contention on free speech. It's a presumption which is a judicial norm which does not free judges concerned of their ethical obligation manifested in the Constitution and the Code. We now know that every person, including a judge, is required under Section 65 to respect courts and respect their processes. One must look at that presumption, if ever it exists, in the light of the obligation of all, including judges, in terms of 165. One must also look at that part of the presumption in line with the oath of office judges have taken. One must also look at that presumption in the light of the rest of the ethical standards set out in the code, which I have taken the courts to, including the obligation to respect judicial processes in relation to the pending judgment. But I'll come to it and show that on the facts, there can never be a contention of an unqualified presumption. Far from it. On the facts, that presumption can be displaced. And I mean, Justice Victor, I'm tempted to make some submission on your point because it's quite critical to deal with the submissions made by.
But make it when you deal with, when you intended to deal with it.
Yeah. In my training, my training is a bit different. When a judge raises a question, you must deal with it. You must not avoid it. So I'm tempted to go there, interrupt myself, and let me go there. You know, one of the issues I'd like to emphasize as a matter of fact is that the ethical standard of respecting the independence and integrity of judges to freely consider their judgments that are pending without outside interference become far higher in respect of the judges of the Constitutional Court for obvious reasons, but let me explore two. The Constitutional Court is the court of final instance. Its judgments provide clear guidance to all other courts. There is every reason to respect their processes. And therefore, the duty of every judge to make sure that judges of the Constitutional Court decide their cases freely, without interference, and by reflecting on their conscience of independence, becomes higher, especially when a matter is pending before it. We now know that on the facts, the case before it, in this case, was a highly controversial case involving people in high office. It was therefore important for the Constitutional Court, as we all know, to get it correct, because there were many concerns that the SCA had gotten wrong, at least by majority. So that's the first point we make, Judge Victor. The second point we make, which applies across all courts, is that judicial processes and the powers of judges to make decisions require a level of trust and confidence by members of society generally. Because we know that judicial outcomes carry with them mixed fortunes for litigants involved in a case. Those who succeed celebrate the success, sometimes go even further and praise judges concerned. Those who fail, of course, get disappointed and therefore at times condemn judges concerned. It is for that reason that the public must have faith in the process and outcome. Imagine if a member of the public, imagine if seriously a litigant were to hear that there was a discussion between a member of the Constitutional Court discussing a case which is pending before them, and you are a litigant involved in it, and that matter is not disclosed in advance of the judgment, then a litigant who fails will not have the type of trust and faith in the process and outcome. It is precisely for that reason we submit that in respect of the Constitutional Court, this court must adopt a standard that effectively protects its processes and outcome and should not tolerate any type of interference. We go further, that on the facts of this case, the interference was improper. So we would submit, therefore, Justice Victor, that the standard which our learned friends propound of an unsuccessful attempt is clearly mistaken, and we ask the court to reject it. Let me go to the application of the standards on the facts. And I propose to deal with our submissions in that regard in a manner which is time efficient. And I deal with issue on the basis that our learned friends for the JP suggested to this court that the majority of the JSC introduced a standard and applied a standard in judicial ethics which does not exist as a matter of law. You would recall that on the facts before the tribunal, there was an issue about whether or not there is a principle of ethics of practice that required that judges of other courts cannot discuss with members of the Constitutional Court cases pending before it. That was a standard which was raised in the tribunal proceedings. The debate before the tribunal was rather different because when it came to his case, Justice Hlophe did not say that the standard does not exist as a matter of fact or law or practice. But his case is that he was unaware of that standard. And I'd like to take the court to parts of the tribunal. But in this review, the case has somewhat changed fundamentally. It is no longer the fact that the standard does not exist as a matter of fact, law, practice, or ethics. It is the fact that the JSC, when it applied that standard, it acted irrationally, unlawfully, and unreasonably. The tribunal dealt with that issue from paragraph 81. well, in fact, yeah, it's 81 of his judgment. The court will find it at 008-2371. And you will see that in paragraph 1, the tribunal refers to a statement supporting the complaint formulated by Chief Justice Langa when he said, elementary principles of judicial ethics precluded a judge of one division from discussing the merits of the matter with judges of the highest court, where the judgment is still pending. And in paragraph 82, the tribunal noted the following. For his part, Judge President Hlophe professed ignorance of this standard. In his response, Judge Hlophe said the following, and the quote, I'm not going to go there. And then in paragraph 83, it says, during cross-examination by counsel for Justice Nkabinde and Justice Jafta, he was asked when he became aware of it for the first time. He answered, the very first time it was when, if my memory serves me well, when Judge Jafta filed his reply. This is when I became aware of it for the first time, because he referred to the practice in the Labor Appeal Court as well as the Supreme Court of Appeal, and he added that he does not know whether I knew about the rule because I never sat in those courts. That was the first time. So the point of contention before the tribunal was not whether Justice Langa was wrong when he said there was this judicial standard of ethics, but that Justice Hlophe did not know about it. And the tribunal went on to make its own findings, and I skipped the rest and I asked the court to look at how it concluded the matter on this score. And it is in paragraph 95 on page 008-2377. And in paragraph 99, the tribunal concluded the matter as follows. We spent much effort discussing this issue, whether it is permissible for a non-panel judges to discuss pending matters with panel judges more than necessary, as it is so tried and would ordinarily brook no debate because of the force with which a senior and respected judge like Judge President Hlophe articulated it. We had his word carries weight and influence. Aspirant and newly appointed judges might take to heart his forceful assertion on this issue as correct. They are not. For their sake, it is important to restate the principle with clarity and ambiguity. And what the tribunal was saying is that the principle has existed time immemorial in this adversarial system of litigation we have. All they had to do was to clarify it on the evidence in the light of the defense put up by Justice Hlophe. And we now know that they have rejected that defense based on their analysis of the evidence from paragraph 1 up to paragraph 94. Justice Ledwaba, what we did in the interest of time was to prepare a table that deals with each of the findings of fact made by the tribunal from paragraph 81 and cross-reference their conclusion on the findings of fact with reference to source material in the record, especially the Rule 53 record. I am told that their table was shared with our learned colleagues for all the parties, and I'm told that you will find it on case line. If I may give you the reference in case line, it is at 015, item 11. We merely did so in order to ease the burden of this court so that if ever there is a need to see whether or not a finding of the tribunal is based on the evidence and the record, you will know where to find it. I'm not going to take time to refer the court to the chapter and verse of those factual findings. We simply submit that they are correct and no one has challenged those factual findings of the tribunal. And so the majority of the JSC itself dealt with those findings of the tribunal and upheld them. And I asked the court to make a note that the majority dealt with the question of whether or not Judge Hlophe knew or should have known about the rule from case line 008-5593 from paragraph 59. And you will see that in paragraph 59.2, the majority refers to a judgment of the JP in State versus Mandlakayise and others. It is cited in footnote 77, where Justice Hlophe applied the standard in a case, but in respect of an assessor. And it did so in order to show that, as a matter of fact, he knew or should have known of the standard. And then the majority. And lastly, I would ask you to take into account what Judge Hlophe himself says in this regard. And I ask you to look at two separate passages of the founding affidavit. One is paragraph 188 at 001-658. And the other is that part of his evidence dealing with the foreign jurisprudence, especially the judgments of the martial inquiries, and I'll give you the reference where you'll find it. It is at 001-92. And you will remember that in that case, there was a reference to an inquiry of a judge who sought to improperly interfere with the works of another judge. And the findings was that because the judge had tendered the apology, there was no case for the removal of the judge. And we rely on that part of Judge Hlophe's version for a different reason. And the reason is this. In this case, we know that when the controversy started, Judge Hlophe filed a counter-complaint of his own and made several serious accusations against the judges of the Constitutional Court. Although the counter-complaint was not gated, the tribunal reflected on the conduct of Judge Hlophe with reference to matters that were set out in the counter-complaint, accusing the judges of the Constitutional Court of serious misconduct. And the tribunal made a finding that it was important for it to make a finding that the conduct of those judges was not as improper as suggested by Judge Hlophe. Far from it. It found that it was necessary to vindicate the integrity of those judges. And it ultimately found that the conduct of Judge Hlophe justifiably triggered the application of Section 1771. We now know that in this case, despite the finding by the tribunal, there has not been a tender of apology by Judge Hlophe to all those judges of the Constitutional Court. I'm not suggesting that he is obliged to do so. Far from it. I'm suggesting that whereas here there are clear findings of fact made by the tribunal based on evidence which, by all accounts, everyone accepts that it is common cause, there would be a need not only to vindicate the integrity of judges accused concerned, but also to tender an apology if ever there is no need to trigger the application of Section 1771 in the light of the jurisprudence Judge Hlophe points out too. So we would submit that the cases he relies on are fundamentally distinguishable from the cases, the facts of the present case. And in fact, we would submit that in this case, where an apology was required and it was not tendered, there is every reason to apply the provisions of Section 1771. And the next issue that I'd like to deal with is the suggestion that the JSC was oblivious of an important standard that had to guide its finding. We would respectfully submit that that submission does not faithfully engage with the report of the majority. You will see that the majority of the JSC itself deals with the standard at 008-5587. And you will see that just above paragraph 47, there is a reference to judicial standard of conduct. And the majority engages with the standard with reference to the judgment of the Constitutional Court I have referred to. And it also engages with that standard over the page, paragraph 48, with reference to the Bangalore principle, especially that paragraph that I have referred to. It then engages with that standard with reference to the code, and does so in paragraph 49.2 onwards. And then quite critically, in paragraph 49.5, at case line 008-5589, the majority makes the following point. As part of the principle of integrity, the notes include: A judge shall ensure that his or her conduct is above reproach in the view of a reasonable observer. That's where we agree with our learned friends for the JP that the standards which is applicable is one that must be based on the objective test of a reasonable man. And then in paragraph 50, the majority engages with the standard with reference to the constitutional oath judges are required to take. And it's a standard that requires judges, both in their processes and their decision, to be free from prejudice, to be free from fear, and to be free from favor. And finally, the majority deals with that standard with regard to the perception that may reasonably and rightly be held by members of the public in paragraph 52. And the rest is there. I'm not going to waste the court's time. It is dealt with in paragraphs 54 and 55 of the majority. So that we would submit that that is a sensible and logical way for the majority to formulate a standard with reference to the applicable and controlling instruments of the Constitution, the Code, the Bangalore Principle, and the Constitutional Court's judgment. It is unfair, with the greatest of respect, for our learned friends for the JP to criticize majority as if it was oblivious to the law and the applicable standards of judicial ethics and probity. And again, I go back to my old hangover. The minority in the JSC has not even challenged that part of the majority report by the JSC. And then what remains for me to do is to support the judgment of the majority by applying that standards on the facts. I'm not going to recount the facts because they are now by and large well known and accepted by all concerned as common facts, common cause. The majority deals with them from 008-5593. And in paragraph 59, the majority expresses its agreement with the findings made by the tribunal. And then over the page in paragraph 60 on 008-5594, it deals with the version of the JP, and it makes points that are obvious given the facts that were common cause. I merely wish to emphasize the following facts in order to support the conclusion of the majority. It is quite clear that one of the litigants in the case pending before the Constitutional Court was Mr. Zuma. And the JP mentioned his name by details in the course of his conversation with Justice Hlophe. He was a litigant in that case. He went further and expressed the view that the SCA got it wrong in that case. So he expressed a personal or professional view in regard to a matter pending before the Constitutional Court with reference to a litigant. He even went further and said that that litigant was persecuted like he was. The unchallenged evidence of Justice Hlophe was that he got an impression that Justice Hlophe was expressing a conclusion in favor of Mr. Zuma. That evidence is there by Justice Hlophe. It has not been challenged. He said it's an impression, but even at the level of that impression, it was clear to him that the JP was looking for an outcome different to that of the majority of the SCA. On those facts alone, there is a clear case of an attempt to improperly influence. The fact that the attempt did not succeed is neither here nor there, because it was not part of the charge. The fact that it did not succeed does not mean that the standard of judicial ethics must be lower. And the majority also made reference to the discussion Justice Hlophe had with Justice Nkabinde. It is accepted by all concerned, but the discussion related to a matter of law that was highly controversial and the Constitutional Court had to decide in that case. And it is a question of privilege. Two things ought to be emphasized in that regard. The first is, he said, that the SCA did not decide that case properly on the question of privilege. The second is that he said without the question of privilege, there is no way that Mr. Zuma would lose the case. And finally, the import of that phrase, Sitambelegenina. All of those things taken into account, they reflect an attempt to improperly interfere. I round up my submissions on all of these matters of fact that are common cause. That this is not a case where Judge Hlophe invited the JP to to come and talk to him about this case. This is not a case where Judge Hlophe invited the JP for assistance on how he should assist him in regard to a matter that he was uncomfortable about the case. This is not the case where Justice Nkabinde sought advice or guidance from the JP. It would have been odd for both of them to have sought that type of guidance from the JP when they are part and parcel of a collective court that was required to discuss the case free from any influence. It is not surprising that both of them have ultimately said to the tribunal and to this court that they were not influenced by those improper attempts, because they were part and parcel of the collective court that had to decide the matter free from external influence. We therefore submit that the evidence on all scores justifies the rationality, the lawfulness, and the reasonableness of the findings by the majority. And we ask the court simply to dismiss this application. Should the court uphold the review, we would submit that the proper remedy is simply to remit. I endorse the submissions made by my learned friend, Mr. Nkatobi, that if the point for upholding the review merely relates to what our learned friends for the JP accepts as technical argument on the composition of the Judicial Service Commission, then the appropriate order which will vindicate that type of review complaint is simply to issue a declaration and leave matters as they are for the next round of the process to evolve in terms of the Constitution. Justice Lejaba, I have said as much as I could say on behalf of my clients. Unless there are further issues the court wishes to raise with me, I will rest my submissions.
Thank you, Advocate Maleka. Colleagues, do you have any issue that you wish to raise with Advocate Maleka? Thank you.
Thank you.
I note it looks like this will be an appropriate time to adjourn, and then I'll hear from you. Should we start at 1:45 or 2 o'clock, colleagues?
I think 1:45.
But at 1:45. Okay.
I agree.
Okay. Yeah, the court will adjourn and then we'll resume at 13:45. Thank you.
Thank you.
Yes. Papers. Is DJP Sutherland with us? Okay. Advocate Marcus, yesterday you indicated that about 1.5 hours will be fine with you.
Yes, my lord, I will do my best. I've listened carefully to what has already been said, and I will not unnecessarily duplicate anything.
Okay, you may proceed. Thank you.
Thank you. My lords and my lady, we propose to address 6 topics. First, we will deal with the nature and ambit of the review of decisions of the present sort. Second, we will deal with the rule prohibiting improper interference or influence with the functioning of the courts. Third, we will deal with aspects of the facts, particularly the issue of premeditation. Fourth, we will deal with the attacks on the Constitutional Court justices. Fifth, we will deal with the role played by the Constitutional Court justices in making the complaint and their participation in the proceedings before the tribunal. Sixth and lastly, we will deal with the Judge President's ultra vires arguments. We have, as you know, filed heads in these proceedings, but we also filed heads and replying heads in the tribunal, to which we will refer in a moment because they deal with the repeated procedural complaints raised by the Judge President. For purposes of this address, my lords and my lady, we have prepared a document which captures virtually all the references to the record and the case law upon which we propose to rely. We had it loaded onto case lines, and you will find it at 014-53. It will save the court from writing down those references, and indeed it will save our learned friends from doing likewise. I will refer to that as my references document. By way of prelude to the 6 topics I propose to address, it is important we submit to be clear about what this case is and is not about. It is not about whether judges may, in general, talk to each other. Of course they can. Nor is it about whether one judge may seek guidance from another judge. Of course they can. Nor is this case about whether the Judge President succeeded in improperly influencing Justices Jafta and Nkabinda. It's common cause that they were not so influenced. Nor is this case about the presumption of judicial integrity. It has no remote application to this case at all. What the case is fundamentally about is the propriety of one judge from an entirely different division and court attempting to improperly influence or interfere with the functioning of 2 justices of the highest court after argument had been heard and when judgment was pending. What occurred, my lords and my lady, was no casual conversation between judicial colleagues exchanging pleasantries, as our learned friend for the Judge President would have it. I will get to the evidence in due course, but by way of overview, it clearly established that on both occasions, it was the Judge President who initiated the discussion about the Zuma tint cases. In the case of Justice Nkabinda, the Judge President's premeditation was clear. He told her in advance in the telephone call to her, arranging his visit, that he was going to be discussing privilege. And 2 days later, that is exactly what he did. And he made it clear to both justices that he thought the SCA had got it wrong. And in both conversations, he expressed strongly held views about privilege, and he said that the Constitutional Court had to decide the matter properly. Now, we cannot approach this case other than by way of the background of the freedom under law decision, which my learned friend for freedom under law will elaborate upon. But for present purposes, all that needs to be said is that the Supreme Court of Appeal in that case held that there was a prima facie case of gross misconduct against the judge president, which had to be investigated and the evidence tested by cross-examination, hence the proceedings before the tribunal. And after the hearing of that evidence, the tribunal held that what started out as a prima facie case of gross misconduct had been clearly established, and the JSC agreed. Both the decisions by the tribunal and the JSC are carefully considered. They both carefully evaluate the evidence and the applicable legal principles. But much as he did in front of the tribunal and the JSC, the judge president has sought to take a range of technical objections to procedural matters with which he apparently persists in this court. And that leads me to my first topic, that is the nature and ambit of the review. Indeed, some of your lordships and your ladyship's questions were aimed at establishing on what basis is this court invited to intervene on review. So the first topic we address, and this is in 1.1 of my references, is whether this is a PAJA review or a legality review. And we point out there that the SCA has twice held that where one is reviewing decisions of constitutional institutions, only a legality review is competent. It's so held in a case concerning the public protector and more recently in a case concerning the Auditor General, and I have given you the references. The difficulty is that the Constitutional Court has cast considerable doubt on whether that is correct. And that doubt was cast in the case of the public protector versus the President of the Republic of South Africa. We've given the reference in 1.2 of our references document. Although the Constitutional Court cast doubt on whether this was purely a legality review, it didn't finally decide the question. Our submission to this court is that it's not necessary for this court to resolve that issue, because even if PAJA applies, no review ground is established. The second point we make under this heading, and you'll find the references beginning at 1.4 of my note, is the point made by us, by the JSC and by Freedom Under Law, that this is a review and it's not an appeal. And we simply respectfully submit that much of the argument, certainly in the written heads of argument by the Judge President, the matter has been treated as if it was an appeal. What he does, as he did both in the tribunal and before the JSC, is he raises once again all the procedural complaints, but without ever indicating a coherent legal basis which would justify intervention by a court such as this sitting on review. So in our references document, we have given you all the references to where this was raised in the tribunal, how it was addressed by the Constitutional Court justices in their heads of argument in the tribunal, and how the tribunal itself dealt with the matter. And that relates to the changes made by Justices Jafta and Nkabinda to their statements, carefully considered and rejected by the tribunal. You'll find all the references in 1.5 of our document. We then refer to the repeated contention that Justices Jafta and Nkabinda were unwilling complainants. Again, we give all the references in 1.6. Then there is the objections to my clients, the Constitutional Court justices, participating in the proceedings. We give those references in 1.7. Then there are the objections relating to the charges and the charge sheets. We give you all those references in 1.8. And then finally, on the procedural objections, the arguments in relation to delay, and we give you all the references in 1.9 of our references document. We stand by the arguments that we advanced to the tribunal, and we submit that the tribunal's rejection of those arguments is simply unimpeachable on review. The short point is this, is that there is no legal purchase in our learned friends for the judge president raising generalized complaints of this sort unless they constitute a material irregularity in the proceedings which causes prejudice. And we submit that they don't come close to meeting those standards of review. Then the third topic in relation to the nature and ambit of the review is simply perhaps the obvious point that this court is concerned with an attack on both the tribunal's decision as well as the JSC decision. Those are separate decisions. They stand on their own footing. And although some of the attacks in relation to the composition of the JSC, of course, are different from those which apply in the tribunal, the point that we make is simply this, is that at worst, and we don't for one moment concede that we have reached this point, if this court were to find that any of the attacks on the composition of the JSC were to succeed, and in addition, if this court were to reject my learned friend's argument for the JSC on remedy, then that would have no bearing on the tribunal decision. In other words, the tribunal decision would stand on its own merits, and all that would happen is that the court would be required to address any potential shortcomings in the JSC decision. And we point out in our heads, and we give you the references in 1.12 of our reference document, that the functions of the tribunal and the JSC are not coextensive. It is the tribunal which is, as it were, the trial body. It is the body vested with the investigative powers. It is the body which has powers of subpoena. It is the body which has the evidence. By contrast, the JSC is empowered, and I use the language of the Act, to consider the tribunal's findings. And as we point out in our heads of argument, that appears to be not akin. It might be akin to, but it is not the same thing as sitting on appeal from a decision of the tribunal. We make that point simply because the JSC Act deals in other places with rights of appeal, but when it deals with the power of the JSC to deal with the tribunal's decision, the word it uses is considerate. We then address what are trite principles of judicial review. We do so in 1.13 of our references document, and we simply make 3 points there which don't require elaboration, but in respect of which we have given you all the references. The first is that a court will not interfere on review unless an administrative authority has committed an irregularity which occasions prejudice. So prejudice is a requirement. Nor will a court interfere on review unless the irregularity is material We refer in that regard to the all-pay decision in the Constitutional Court. We've given you the reference in 1.13.2. Curiously, and I don't address this, but I merely draw the court's attention to it. In that case, one of the arguments advanced concerned a composition issue, whether or not the bid evaluation committee was properly constituted, and in the result, although irregularities were found in the constitution of the bid evaluation committee, the Constitutional Court held that these were not material. The short point is really the one captured by Judge Cameron in the Logbro case to which we refer in 1.13.3, and that is that the subject of an administrative process is not entitled to a perfect process. So it's really quite unhelpful for the Judge President to snipe at the periphery of these various procedural issues unless he can establish prejudice and materiality. And perhaps just to round off this point, and this is not in my notes, if I could give you the reference, what is quite clear from the debate that has thus far taken place is that this court is confronted with various practical problems around the unavailability of certain members of the JSC. And we would merely refer to what has often been stated by the Supreme Court of Appeal. And I quote, "Courts should not be overawed by practical problems." That was said in Modderfontein Squatters versus Modderklip Boerdery, and the reference is 2004, volume 6 of the South African Law Reports, page 40, Supreme Court of Appeal, and at paragraph 42. But it has been said many times outside of that context as well. Then, still dealing with the nature and ambit of the review, at 1.14 of our notes, we simply deal with the repeated contention by our learned friends in their heads that certain comments made by Judge President Mlambo in the course of the discussion at the JSC founds a basis for review. That respectfully is wrong in principle, and the correct approach is laid down, it was laid down a century ago by the English courts, but captured in the decision to which we refer in 1.15. It's the case of Sims versus Salisbury Liquor Licensing Board. And in that case, quoting the English decision, it said, "I should think that there are probably few debates in which someone does not suggest as a ground for decision something which is not a proper ground, and to say that because somebody in debate has put forward an improper ground, the decision ought to be set aside as being founded on that particular ground is wrong." And then that takes us to my second topic, and that is the rule against improper interference or influence. That appears to some extent to be the central issue in the submissions by our learned friends for the BLA, and it is certainly a refrain in the Judge President's argument. So we deal with this topic under various headings, the first of which is the source of the rule. And the source of the rule is really very easy to find. It's section 165(3) of the Constitution. No person or organ of state may interfere with the functioning of the courts. And of course, it's also a rule embodied in section 165(4). Let me pause there. What I'm about to address is the source of the rule, the contents of the rule, and the judicial pronouncements in respect of that rule, all of which existed or were made before the conversations in question took place. In other words, what I'm submitting to the court is that these are established and clear standards, and they rebut any suggestions that the rule was vague or unclear or anything of that sort. So the starting point is the Constitution itself. sections 165 and 163. Then there are the international standards. Now, we dealt with those international standards in the hearing before the tribunal, and we referred to the United Nations Basic Principles, the Bangalore Principles, and in addition, we referred to the guidelines for South African judges, which were published in 2000 in the South African Law Journal. We give the references in 2.2 of our reference. Can I, for present purposes, merely stress the United Nations Basic Principles on the independence of the judiciary? Article 1 and 2 of those basic principles are absolutely clear. Article 2 says this, and let me read it, and the court will be sensitive to the use of language employed in that provision. It says, the judiciary shall decide matters before them impartially on the basis of facts and in accordance with the law, without any restrictions, improper influences, inducements, pressures, threats, or interferences, direct or indirect, from any quarter or for any reason. So this, again, I'll come to it in a moment, this semantic quibble about influence and interference is really a make-weight, which has no bearing on the underlying principle. The basic principles for the independence of the judiciary, as I say, were relied upon by us in the tribunal, and in fact, they form part of the record. This is not in my reference document, but you will find it at 008-4954. And reverting to our heads in the front of the tribunal, we referred to the Bangalore Principles. It's set out there, and importantly, the guidelines which were published in the 2000 South African Law Journal. In addition to that, there were the two pronouncements by the Constitutional Court in De Lange versus Smuts and Van Rooyen versus the State, which this court has now heard many times, about no outsider, including any judge, may interfere with the functioning of the courts. The Constitutional Court had twice laid that down. It subsequently repeated that, but twice laid that down before the judge president made his fateful approach to Justices Jafta and Nkabinda. So what we submit is that the repeated complaints in the judge president's heads about the non-existence of this rule, or the complaints about the alleged vagueness of this rule, are devoid of substance. Our learned friends for the BLA spent a considerable amount of time with a semantic distinction between interfere and influence. But our learned friends lose sight of two things. The first is that the charges which were presented to the judge president used both terms. It alleged that during the period in question, two judges of the Constitutional Court, to wit Jafta AJ and Nkabinda, and here are the words, that the judge president, and I quote, attempted to improperly interfere or influence their decision. And in answer to Justice Victor's query to my learned friend about the recourse to dictionary definitions, the point, it's not that the meanings of interfere or influence are the critical issues. It's the fact that the adjective improper is the one which gives the guidance to when the influence or the interference falls foul of accepted standards of judicial ethics and conduct. what is curious about our learned friends for the Judge President's complaints is that although there are these repeated concerns expressed in the heads of argument and the alleged vagueness of the rule, our learned friends in their heads at other places concede, and I use their words, that a private conversation would, and I quote, amount to an improper attempt to interfere with the functioning of the court and therefore become gross misconduct. They acknowledge that. I've given you the references in paragraph 2.4 of my references document, and they pose the question in their heads. The question they pose is, at what point do remarks on a pending matter by one judge to another in the course of a private conversation amount to an improper attempt to interfere with the functioning of a court and therefore become gross judicial misconduct? That question is posed at paragraph 95 of the heads, all the references I've given you in 2.4, but they answer that question themselves. They answer the question at paragraph 98, in which they say the answer to the above question, therefore, is that remarks or comments on pending matters may be considered to constitute an improper attempt to interfere with the functioning of the court when the remarks undermine the public's confidence in the proper functioning of the courts. Private remarks may undermine the proper functioning of the court where there is evidence that they were made to improperly influence the fair and independent adjudication of a matter. This is where a private remark promotes corruption or seeks to improperly persuade a judge from making an independent and impartial judgment. For this rule, it does not matter who approached who. So we are respectfully a little bewildered by our learned friend's inconsistency in the arguments that he advances, because he acknowledges, not only in that place, but in others, and I've given you the references, that there are circumstances in which a private discussion may amount to improper interference. So the question which faced the tribunal and the JSC, and in a different context confronts this court, is a fact-based inquiry. And it was for the tribunal to determine those facts, and it did so. And the JSC endorsed those factual findings, and hence the question is, on what basis, given the facts, can this court as a court of review intervene? And we submit that there is none whatsoever. And both our learned friends for the Judge President and for the BLA refer to several cases, South African cases, which from the judgment it appears that the judge in question spoke to or sought guidance from other judges in the division. We've given you the references in 2.5 and 2.6 in our references document, but those examples are simply not remotely concerned with the facts in the present matter. Not one of them concerns an attempt by a judge from a different division trying to influence the outcome of a pending matter in the highest court, nor do any of them involve a situation where the approach from the outside judge was wholly unsolicited. Then, still dealing with the content of the rule, there are extensive arguments advanced by our learned friends for the Judge President, in which they contend that the Judge President was denied the constitutional protection of Section 16 of the Constitution, and for good measure, they throw in Section 15 as well, the right to freedom of belief and opinion. We give you some of those references to their heads in 2.7 of our references document. The argument, respectfully, is misconceived. And the starting point is a recognition by our learned friends that these rights, the rights to freedom of expression and the rights to freedom of belief and opinion, are limited Our learned friends acknowledge this in their heads, and we give you the reference in 2.8. They acknowledge that it is limited in two ways. First, they say by the judge president's obligations as a judge. And secondly, they acknowledge that it is limited by section 165(4) of the Constitution. Why they single out 165(4) and not 165(3) is not clear, but quite plainly, whatever rights to freedom of expression judges have, and we accept, of course, they do have such rights, they are not untrammeled rights. But most importantly, our learned friends lose sight of section 36(2) of the Constitution, because section 36(2), which is the limitations clause, we are all, of course, familiar with 36(1). That's the clause that courts deal with every day in deciding whether or not there is justification for a limitation. But 36(2) says this: except as provided in subsection 1 or in any other provision of the Constitution, no law may limit any right entrenched in the Bill of Rights. Here we are dealing with a limitation in the Constitution itself, because sections 165(3) and 4 undoubtedly limit a judge's freedom of expression. But the argument advanced by our learned friends fails on its own terms, because our learned friends themselves acknowledge that there are distinct limits on judicial free speech, and they make concessions in that regard, and we've given you the references to where those concessions are made. Perhaps I should just refer to one of them. I've given the reference in 2.9. It's in their heads of argument at 107, where they say, nowhere does Judge President Hlophe advocate for the protection of constitutional rights in circumstances where to do so would constitute interference with the functioning and independence of the courts. So they acknowledge that limit, and once again, we are driven back to a factual inquiry in respect of which there is simply no basis for intervention by a court of review. Merely to round this off, and we draw this to the court's attention because of the inconsistencies in our learned friend's argument, that despite the concessions to which I've drawn attention, they say, and again I give you the reference in 2.9 of my references document, but it's paragraph 130 of their heads, they say, and I quote, there is no known democracy that regulates the private conversations of judges or considers private remarks or comments on pending judgments made in the course of a private conversation or discussion or debate between judges to be judicial misconduct or evidence of any attempt to interfere with the independence of the judiciary. Well, that is a startling proposition in and of itself. It is belied by the domestic and international standards to which I have referred, and it is plainly incorrect. Part of the problem in our respectful submission is that our learned friends constantly mischaracterize the issue. There is copious reference in their heads of argument to judgments from the European courts, from the Inter-American court and elsewhere. But those cases deal with an entirely different situation. They deal with the prohibition, and these are my words, on judges engaging in political activities, or to use the language of our code of conduct, the prohibition on judges getting embroiled in political controversy. They have nothing to do with attempts at improper influence or interference. So, for example, the case in the European court, again, my lords and my lady, I give you all the references in 2.10 of our note. The reference to the European court decision in Baku versus Hungary concerned the termination of a judge's tenure as president of the Supreme Court following his public criticism of various legal reforms which he considered undermined judicial independence. The same is true for the case in the Inter-American Court in Lopez versus Honduras. That case concerned the dismissal of various judges because they spoke out against a coup d'etat and in favor of establishing a democracy and the rule of law in Honduras. The Marshall inquiry, to which our learned friends refer quite extensively, concerned comments made by a court, a Canadian court, in the course of their judgment. So the context of those cases is entirely different. The misconception and mischaracterization is most starkly exposed by our learned friend's reference to the Canadian Judicial Council's ethical principles for judges. We give you those references in 2.10 of our document, and we urge this court to pay particular attention to the ethical principles for judges from Canada, because as this court will be aware, the Canadian cases have been far and away the most influential decisions in this sphere of our law. They are the cases which are referred to repeatedly by the Constitutional Court. So what our learned friends do is they refer to Rule 6D, that judges should refrain from taking part publicly in controversial discussions, except in respect of matters directly affecting the operation of the courts, the independence of the judiciary, or fundamental aspects of the administration of justice. Now, if one goes to those ethical principles for judges, and I don't know whether they've been made available by our learned friends to this court, but if they haven't, we will make them available. Rule 60 appears under the heading political activity. It is concerned with the proper limits on judges engaging, broadly speaking, in political activity. Now, our learned friends don't content themselves with quoting the wrong principle. They go on to accuse the tribunal and the JSC of simply ignoring these considerations by conducting an in-depth analysis on this complex and novel subject, and contending that, and I quote, ignoring these important legal principles essentially violated the fair adjudication of the dispute against Judge President Hlophe, unfairly and unreasonably transforming an innocent conversation into one with improper motives. We give you those references from their heads at 2.10. But our learned friends invoke the wrong principle. I'll simply read them to you. The first principle is, 1, judges must exercise their judicial functions independently and free of extraneous influence. 2, judges must firmly reject any attempt to influence their decisions in any matter before the court outside the proper process of the court. And if one goes to the commentary on that principle, the principle that applies to this case, one finds the following. Judges must, of course, reject improper attempts by litigants, politicians, officials, or others to influence their decisions. And they then go on to quote from a book written by the Honourable J.O. Wilson, and in which the author concludes, and I quote, regardless of the source, ministerial, journalistic, or others, all such efforts must, of course, be firmly rejected. This rule is so elementary that it requires no further exposition. That, respectfully, is what we are dealing with. We are dealing with a rule which is absolutely intrinsic to the very judicial function. And respectfully, the attempts by our learned friend for the Judge President to avoid that which is elementary are simply unworthy. Then, to round off this, well, almost to round off the section on the rule, there is the question of seriousness, a matter to which our learned friends for the BLA devoted a fair amount of time. We are, again, constrained to respectfully submit that the arguments advanced by our learned friends, particularly the BLA, that the threshold of seriousness was not met in this case, is wholly without substance. And we say so really for the following reasons. Firstly, the debate is foreclosed by the SCA decision in Freedom Under Law. That court has held that prima facie the conduct in question, if proven, amounts to gross judicial misconduct. That is respectfully the end of the matter. But secondly, the seriousness of what occurred, we would respectfully have thought is self-evident. And as we put it in our heads in the tribunal, and we give you the references in 2.12, we said this: if proven, there is little doubt that the judge's complaint would constitute gross misconduct. One, it would amount to a crime or crimes against the administration of justice, more particularly attempting to defeat or obstruct the administration of justice or contempt of court. Two, it would entail a serious interference with the constitutionally protected independence of the judiciary. And three, it would entail an attempt to induce justices in Nkabinda and Jafta to violate their oaths of office. Can I then finally, under this heading, deal with the invocation by our learned friends of the presumption of judicial integrity? You will find this in 2.13 of our references, and the charge by our learned friends is a serious one. They contend that the JSC, and I quote, did not deal or refer to the role of the principle of the presumption of judicial independence and integrity, which is extended to judges and recognized in our law in judging whether a judge's remark or a pending matter was not protected by such a presumption. And they go on to say that the failure by the JSC to accord the Judge President Hlophe the presumption of judicial independence, integrity, and impartiality is irrational and does not accord with the proper adjudication of the dispute. We submit that this argument is misconceived for three reasons. First, the presumption upon which our learned friend relies is one that arises in the context of recusal. It holds that a judge whose recusal is sought enjoys a presumption of independence and impartiality. It has, in our submission, no application outside that sphere. One can test it practically. On our learned friend's argument, assume that a judge hires a plumber to install a geyser at their house, and assume that a dispute arises about payment for the work done. It would be absurd to suggest that in those circumstances the judge enjoys a presumption of independence, integrity, and impartiality. Secondly is the point that my learned friend Mr. Maleka has made, and that is that if we are wrong, that this principle has some broader application outside the context of recusal, then it is a rebuttable presumption. And in that regard, we refer you, I've given the reference in 2.14.2 to the recent Constitutional Court decision in Amabungani Center for Investigative Journalism versus the Minister of Justice at paragraph 89, where the court said this: it is generally expected and accepted that judges act independently, impartially, and fairly without bias or prejudice. This is supported by the burdensome onus on an applicant for recusal of a judge, which is based on the presumption that judicial officers are impartial. But it does not mean that judges are infallible, nor does it mean that there is no possibility that judges may attempt to abuse their office. As judges, we should not, because of our own belief in our independence, be sanctimoniously dismissive of the fact that we may be susceptible to these ills. Indeed, Nelson explained, that's an author, that, and they quote, "It would not be realistic for judges to assume a sanctimonious or puritanical attitude." So, thirdly, we need not speculate about the appropriate standard and the application of this presumption, because the SCA has spelled it out, not only in the freedom under law decision, but also in its decision in Nkabinda versus the Judicial Service Commission, and we've given the references at 2.14.3 of our notes. Can I then turn to the facts? Now, it's quite clear from the interaction between your lordships and your ladyship that you are familiar with the facts. And I therefore propose only to emphasize one aspect of the facts, and that is the question of premeditation. We have addressed this fully in our heads of argument, and we have given you the references in paragraph 3 and following in our references document. And you will know that the approach that we take before this court, as well as the approach we took in front of the tribunal, is that the facts were established on the judge president's own version. And we set that out in some detail in our heads. And of course, those facts were bolstered by the evidence of Justices Jafta and Nkabinda. When your lordships and your ladyship come to assess the facts, could we ask you to do so in the light of what we submit is a remarkable contention by our learned friends? We give you the reference in 3.1 of our note, and it's from paragraph 129 of their heads of argument, where they say this, I quote, "There is no evidence that the judge president tried to suggest the direction in which the pending judgment should go and why." We say that's an astounding submission because the uncontested evidence, indeed the evidence from the judge president himself, goes in precisely the opposite direction. What we also submit to the court is that in assessing, there are 3 guiding principles which we submit should be applied. We identify those in 3.2.1 of our notes. And the first of those guiding principles is one which we do not understand, contested, and that is that the matter context and assesses objectively what the words conveyed. The second principle, which we derive from the law of defamation, which we submit is of equal application here, is that one considers both what was actually said as well as what was implied. That certainly is the accepted approach in defamation, and we submit it applies equally here. We have given the court the references. Indeed, in the tribunal, we referred to an article by Cynthia Gray entitled "Avoiding the Appearance of Impropriety," and we quoted from that article in our heads, where the author made the point as follows: "More subtle, less bald-faced, but still attempts to gain an improper advantage from the judicial office are captured by the appearance of impropriety standard and represent the largest number of cases of impropriety. This application of the appearance standard reflects the reasonable person's understanding that much of human communication is unspoken between lines with winks and nods and depends on what goes without saying. Incidentally, the article, the Cynthia Gray article, is part of the record before the court, and the part that I've just read is to be found at 008-4963, but the whole article is part of the record. The third principle we would urge upon the court is the broad context in which these communications occurred. And what we know from the judge president's is that these conversations occurred in an atmosphere, in a political atmosphere, in which political change was in the air, and the likelihood, as suggested by the judge president himself, that Mr. Zuma would be elected as president. That is the context in which these discussions took place. They did not take place in a vacuum, and the tribunal correctly recognized that in its decision. If I could then turn to the evidence of premeditation. It is set out in some detail in our heads. I've given you the references in 3.5 of my notes. But the short point is this, is that, and the sequence 3 days, from the 23rd of April 2008 to the 25th of April. And it is very simple and straightforward. On the 23rd of April, Justice Nkabinda receives a call from the judge president. And he foreshadows that he wants to talk about the issue of privilege. The next day, Justice Nkabinda has lunch with Justice Jeff, and that he had mentioned that he wants to talk about. And it was the mention of privilege that triggers Justice Jafta's own recollection of his meeting with the judge president 3 weeks earlier, and he cautions Justice Nkabinda that he may wish to talk about the Zuma tint matter. The next day, the promised meeting takes place, and lo and behold, the judge president talks about privilege and the Zuma tint matters. Now, that is plain and unmistakable evidence of premeditation. The sequence of events that I've just described with you, I took Justice Jafta through carefully in his evidence before the tribunal. Not only was there no cross-examination directed at that sequence at all, there was no cross-examination directed at the proposition that Justice Nkabinda had mentioned in her conversation with Justice Jafta, what had occurred in her conversation with the judge president. No cross-examination whatsoever. On the contrary, and I've given you the references in my notes, the cross-examination of Justice Jafta proceeded upon an acceptance of the correctness of her recounting of her conversation with the judge president. And if we just take a pause here and consider what would have been required for this evidence of premeditation to have been rejected by the tribunal and then the JSC. First, Justice Nkabinda would have had to have found to have lied when she said that the judge president mentioned on the phone that he wished to discuss privilege. Second, it would have had to be found that both she and Justice Jafta lied when they both testified that they spoke about the judge president's conversation the next day in which he raised the question of privilege. If Justice Nkabinda is to be disbelieved that the issue of privilege was mentioned in the phone call, it follows logically that her mention of it the next day to Justice Jafta was also a lie. And thirdly, Justice Hlophe would have also lied when he recounted that conversation. And moreover, he must have been found to have lied when he said that it was the mention of privilege which triggered his own recollection of what had occurred with his meeting of the judge president 3 weeks before. Now, all of that's impossible, leaving aside the fact that it was not the subject of any cross-examination directed at Justice Hlophe at all. And the high watermark of the cross-examination of Justice Nkabinda was a putting to her of a proposition that the judge president didn't mention privilege. So what we submit respectively, that evidence is really destructive of the judge president's case. It's destructive of his attempts to suggest that he didn't know of the existence of the rule. It's destructive of arguments a bit of the rule and when the line is crossed, etc. And the JSC rightly found that the judge president must be taken to have known of the rule and its existence. And in the JSC's decision, the first reason that they advance was this, and we give you the references at 3.7. They say, the matter in discussion Justice Hlophe. Justice Hlophe had rebuffed him. Notwithstanding this rebuff, Judge President Hlophe still proceeded to arrange a meeting with Justice Nkabinda, in which he again pursued a discussion regarding the Tint Zuma cases, knowing she had sat on the bench and judgment was still pending. Our learned friends say this. We give you the references at 3.7. I quote, "There is no evidence that Justice Hlophe rebuffed Judge President Hlophe. Justice Hlophe did not say so, and the Judge President did not say so. Where this came from is altogether unclear, and they go on to accuse the tribunal of acting in an irrational and unreasonable way, because on that argument, there was no evidence of rebuffing. But they are mistaken. They are mistaken in this regard, and we give the references in 3.7 of our references document. In his evidence before the tribunal in April 2009, Justice Hlophe said this. So I thought in that context, I would have dealt with the matter effectively and decisively by rebuffing the approach by the judge president. And the questioning by other members of the Judicial Service Commission pick up on that word. So Mr. Ngubani says, and you were relying on memory on a discussion which to you had rebuffed. And I take it you might have decided to forget about the details of the context. Justice Hlophe says yes, but he doesn't dispute the rebuffing. And the chairperson, who, if memory serves, was Justice Mpati, picks up on that as well. He says, I just want to understand, I want to be clear in my mind that when you made your rebuff or gave your rebuff and the JP stopped to discuss the matter thereafter and went on to discuss other matters, your rebuff was merely so that he, not having been party to the hearing, shouldn't discuss the matter further. And Justice Hlophe says, that's correct. So once again, respectfully, there is simply no basis for the arguments advanced by our learned friends on the facts, the ambit of the rule, and the judge president's knowledge of the rule. Can I then move to my fourth topic, and that is the attacks on the Constitutional Court justices, and the references upon which I rely are found in paragraph 4 of my references note. And the argument by our learned friend is this. They say, I quote from their heads, the JSC disregarded the law and ignored the evidence, endorsing instead the irregularities of the tribunal that saw its obligation as the vindication of the honor of the justices of the Constitutional Court. And this, they go on to say, and I use their words, this is said to evidence, quote, blatant bias. I give you the references in 4.1. We submit that that argument is spurious for 4 reasons. The first, and we give you the references in 4.2.1, is this, is that when the judge president first responded on oath to the allegations against him, he chose by way of his defense to those charges of misconduct to accuse every member of the Constitutional Court of falsely fabricating the complaint against him. He did so repeatedly, and he did so vehemently, and that stood as his evidence in the tribunal. So, if the judge president persisted in this defense, it was plainly incumbent on the tribunal and the JSC to determine, and I stress potentially in the judge president's favor, whether this defense was sustainable. Then we move on to what happened in the tribunal, and I give you the references in 4.2.2 of my note. In the proceedings before the tribunal, the judge president in his heads of argument did indeed persist with his attacks on Justices Hlophe and Nkabinda, accusing them of being unduly influenced and being subject to undue pressure. And they did this despite the fact that there was not a scrap of evidence to support those allegations. We addressed those submissions in the tribunal in our replying heads because they had now been made an issue by the judge president himself, and Justices Hlophe and Nkabinda likewise addressed those allegations in their heads, and I've given you the references in 4.2.2. So the tribunal had to deal with those allegations. It pointed out in its judgment, as I've indicated, that the judge president persisted in those attacks, and it said as much in paragraph 120 of its ruling. Then in the tribunal, then the matter goes to the JSC, and before the JSC, the judge president once again persists with the attacks, accusing Justices Hlophe and Nkabinda of submitting to, and I quote, pressure from colleagues, and again I quote, and not having acted freely and voluntarily. We give you those references in 4.3, and the references where they make those attacks to the JSC in their heads of argument to the JSC. Indeed, perhaps I could just read one of those attacks to you. It's to be found in paragraph 152 of their heads in the before the JSC. You have the reference. They said this: given the above considerations and without more to explain the situation, it is submitted that the conduct of Justices Hlophe and Nkabinda suggests that there was pressure brought to bear upon them, and as a result of which a reasonable inference is inescapable that they unwillingly deposed to affidavits, the contents of which they went to amend and change some 12 years later. So, like the tribunal, the JSC was obliged to deal with the matter, and in these very proceedings for judicial review before your lordships and your ladyship, the judge president persists in the attacks once again. We give you the references in 4.4 of our note. They pose the question, was the joint complaint statement by the Constitutional Court judges and subsequent evidence freely and voluntarily made by Justices Nkabinda and Hlophe? And they answer the question in their heads at paragraph 197. The inference is inescapable that Justices Nkabinda and Hlophe's attestation to the joint complaint statement and their subsequent testimonies, given their earlier stance, were not done freely and voluntarily, but as a constant consequence of pressure from colleagues. They vehemently deny any pressure and even deride the suggestion that they were impressed upon by their colleagues to collaborate in filing a joint statement. However, the evidence suggests that there was pressure and influence through meetings with their colleagues. So what we see is this constant defense raised by the judge president that the complaint against him was not a genuine complaint. It was the product of undue coercion and pressure brought to bear on Justices Jafta and Nkabinda. That has been his defense from the outset. He advanced that defense in front of the tribunal. He advanced that defense again in front of the JSC, and he persists in that defense in this very court. So both the tribunal and the JSC were obliged to deal with it. There is a third reason. I said his argument was 4 reasons. The third reason by the tribunal, in which they refer to a case, the case of Society and manner in which a legal professional, in that case an advocate, conducts is relevant. And the Erdeland case, but more than that, referred to the English decision of Moran versus Lloyd's. Court accusing the accusers. And Lord Denning said this kind of behavior. Now we refer to Moran versus Lloyd's because it itself was cited with approval by the Supreme Court of Appeal in the case of Lang versus Hlophe. In other words, in this. So the manner in which the judge president chose to conduct his defense was plainly a relevant issue. The Judicial Service Commission making that.
Okay.
Because I'm now on my second last topic, and that is the role of the Constitutional Court justices. Again, your lordships and ladyship will find this in paragraph 5 of my references document. Well, the point here is this, is that both the judge president and the BLA contend that judges, like those whom I represent, who hear of allegations of alleged misconduct involving another judge should, and I quote our learned friends for the judge president, they say, protect their independence, impartiality, integrity and effectiveness by staying away from the fray. And our learned friends for the BLA make a similar argument. Our learned friends for the BLA speak of this being a questionable procedure. I don't understand what that means. It's either a material irregularity or it isn't, and it plainly is not. But the arguments go nowhere once again in the first instance, because the SCA in Freedom Under Law has determined that the complaints against the judge president had to be determined by the JSC and its organs, and that really ought to be an end of this argument. But we say, and this might be important, but certainly important from the perspective of my clients, it's important to understand why it is that the justices of the Constitutional Court, led by the late Chief Justice Langa, saw fit to raise a complaint with the Judicial Service Commission as the body constitutionally mandated to deal with matters of judicial misconduct. Our learned friends for the JSC say in their heads, and I think I've given the reference, but it's at paragraph 22 of the heads. They say, judges who hear through the grapevine of allegations of judicial misconduct involving another judge should instead protect their independence, impartiality, integrity, and effectiveness by staying away from the fray. That reference to hearing through the grapevine is unnecessary sarcasm. The justices of the Constitutional Court heard of what happened from their colleagues, fellow justices of the Constitutional Court, with whom they work every day, in whom they repose their unequivocal trust. And it was in circumstances in which they perceived an improper attempt to influence those two judges that they lodged the complaint with the JSC, because they feared the potential impact of that conduct on the integrity of the Constitutional Court as an institution. Now, in our heads of argument, we have set out the paragraphs from the complaint lodged by the late Chief Justice. I've given you the references, but it's in paragraph 9 of our heads. And I wonder if I could just say something about it. I'm quoting from Chief Justice Lange's complaint. He said, the attempt to influence Nkabinda J and Jafta AJ in the manner described above was calculated to have an impact not only on the individual decisions of the judges concerned, but on the capacity of the Constitutional Court as a whole to adjudicate in a manner that ensures its independence, impartiality, dignity, accessibility, and effectiveness, as required by Section 165(5) of the Constitution, and constituted a breach of Section 165(3) of the Constitution, which prohibits any person or organ of state from interfering with the functioning of the courts. They then go on to refer to their own decision in President of the Republic versus Safu, in which the court noted that if one member of a court is disqualified from sitting in a case, the court is under a duty to say so and take such steps as may be necessary to ensure that the disqualified member does not participate in the adjudication of the case. It goes on to say, it follows that every member of the Constitutional Court not only has a direct and substantial interest in any improper attempts to influence the decision-making process required of any member of the Constitutional Court, but a duty to ensure that all judges who sit in a matter are qualified to do so. It is in light of these obligations and the seriousness with which the judges of the court viewed the conduct of Hlophe JP that the judges of the court, including Moseneki DCJ and Sachs J, unanimously made the complaint to the JSC. So, that is what happened. That was the motivation for why the court considered what had occurred to be a threat to the integrity of the court as an institution. That motivation was accepted by the Supreme Court of Appeal in the Freedom Under Law decision. Because of what occurred, the Constitutional Court felt obliged to issue directions to the parties involved in the Zuma Tint cases and to call for representations from them. The directions which the court issued form part of the record in this case, and we give you the reference at paragraph 5.2 of our references document, and the issue was indeed addressed in the Constitutional Court's judgment on this issue, and we likewise give the reference in our references document. So what we submit is that our learned friends contentions in this regard, where they contend, we give you the reference in 5.4, that it was not, I beg your pardon, let me go back a step. That is the genesis of the lodging of the complaint. The matter then comes before the tribunal, and the parties to the complaint, namely the Constitutional Court justices, are represented in the proceedings before the tribunal. Our learned friends objected to our participation in the tribunal, and the tribunal made a ruling in that regard. They have not advanced a single cognizable basis which would justify interference on review with that ruling. Our learned friends nevertheless contend in the heads of argument before your lordships, we give you the reference in 5.4, that it was not lawful for the tribunal to allow the legal representatives of the Constitutional Court judges the right to cross-examine Judge President Hlophe, to supplement and complement the NPA's role as the designated body to conduct the prosecution of the charge of gross misconduct. Respectfully, that is an argument devoid of merit. It ignores the fact that the Constitutional Court justices have from the outset been part of an institutional complaint to the JSC, that 6 judges of the Constitutional Court testified in support of that complaint in April 2009. They participated fully in all the proceedings before the tribunal, and their interest in participation is in fact set out in detail in the application to intervene in these very proceedings, which your lordships and your ladyship will recall was ultimately not opposed. And what our learned friends ignore entirely is the reliance by the tribunal on section 25(4) of the JSC Act, which empowers the tribunal to regulate and protect its own proceedings, and the ruling relating to our participation was expressly made in terms of section 25(4), and that is referred to in paragraph 59 of the tribunal's ruling. That brings me to my last topic, and I've got 10 minutes left and I will finish. It's the ultra vires argument. Our learned friends for the judge president contend that the tribunal does not have the power to make a finding of gross misconduct. That, they argue, is reserved for the Judicial Service Commission. Respectfully, that misconceives the statutory framework. We give the references in paragraph 6 of our references document. Section 26(1) of the Act makes clear that the tribunal inquires inter alia into allegations of gross misconduct by collecting evidence, conducting a formal inquiry, making findings of fact, and making a determination on the merits of the allegations. A determination on the merits of the allegations. 26(3) echoes that wording. It says, when considering the merits of any allegations against the judge, the tribunal must make its determination on a balance of probabilities. And section 33, which is headed findings and report, it makes clear that the tribunal must, and I quote from the section, record its findings of fact, and I quote, its findings as to the merits of the allegations in question, and it must submit those findings and the reasons for them. Now, the ordinary meaning of determination from the Oxford English Dictionary, which we give in 6.3 of our heads, is the settlement of a suit or controversy by the authoritative decision of a judge or arbiter. A settlement or decision so made, an authoritative opinion. On the ordinary meaning of the words of the statute, it is submitted that the tribunal not simply had a power, but had a duty to make a finding on the merits of gross misconduct. So that argument, the ultra vires argument, we submit is bad. They make a secondary argument and they say that the tribunal went beyond the ambit of its scope of work. And for that, they rely on paragraph 123 of the tribunal's decision. It's possibly a good idea to go there because paragraph 123 must be read with 124. Paragraph, I beg your pardon, the references we've given in 6.4 of our references document. But the tribunal concluded thus in paragraph 123. They say, in conclusion, on an objective and proper consideration of the facts and probabilities, we find that A, Judge President Hlophe's conduct breached the provisions of section 165 of the Constitution in that he improperly attempted to influence the two justices of the Constitutional Court to violate their oaths of office. B, his conduct seriously threatened and interfered with the independence, impartiality, dignity, and effectiveness of the Constitutional Court. And C, his conduct threatened public confidence in the judicial system. And then paragraph 124 is important because they say, in our view, this, in other words, what has gone before, what is mentioned in 123A to C, this constitutes gross misconduct. So if one goes then to the terms of reference for the tribunal, and I've given you the terms of reference are in the record. I've given you the reference in 6.5. The terms of reference require the tribunal to do this. It says the tribunal shall investigate, make findings, and report on, first, whether the respondent attempted to influence improperly justices Nkabinda and Jafta of the Constitutional Court to decide matters that were pending before the Constitutional Court in favor of any of the litigants, and two, if so, whether the respondent is guilty of gross misconduct as contemplated in section 177 of the Constitution. So the first part of their terms of reference is a factual inquiry. The tribunal is required to investigate, make findings, and report on whether there was an improper attempt made with Justices Jafta and Nkabinda to influence them in pending matters. That's a factual inquiry. If they conclude that there was such an improper attempt on the facts, the second part of their terms of reference required the tribunal to determine whether that amounted to gross misconduct as contemplated in section 177 of the Constitution. If you look at paragraphs 123 and 124 of the tribunal's decision, the tribunal did precisely that. It first of all found that the judge president did attempt improperly to influence the two justices. Secondly, it found that this constituted gross misconduct, so that comports precisely with the terms of reference. But it then went on to explain the reasons for the latter conclusion, namely that the judge president's conduct had breached 165, etc. And that was a requirement of section 33B1 of the Act, which required the tribunal to record its findings and the reasons for them. So in our submission, those two arguments are devoid of merit and they ought to be rejected by this court. Justice Ledwaba, I think I've made it by 3 minutes, but there might be injury time by questions from any of your lordships or your ladyship.
Or from me. JP Sutherland, you are muted. Can you unmute?
Yes, thank you. Sorry about that. I have two questions I'd like some clarity on. If we can look at the facts to start with, the controversy around the changes of the statements by Judge Hlophe and Judge Nkabinde. Record demonstrates, as I understand it, that these were introduced during the proceedings by counsel representing them to amplify and adapt. Am I correct in understanding that at the time when that was done, it was in the context of the statements that had already been adduced earlier, standing as evidence in chief, and therefore those statements would then, in their amplified form, constitute the totality of what they would be cross-examined on?
Justice Sutherland, your understanding is entirely correct.
Yeah.
The agreement was that evidence given on oath by Justices Jafta and Nkabinde, who had testified, well, they had given evidence on oath in judicial proceedings. They had given evidence on oath before the Judicial Service Commission in April 2009. Evidence given on oath by Judge President Hlophe would stand as evidence before the tribunal. But your lordship is absolutely correct that in the case of Justices Jafta and Nkabinde, it was to stand as their evidence in chief.
Yeah. And the second question I've got is purely a question of law. In thinking about the relationship between the tribunal and its function as a sort of handmaiden of the JSC, are we to regard the scheme of the Act as creating a sui generis relationship between the JSC as the sort of mother body and the tribunal as its handmaiden, or is there a more generic principled context in which that kind of relationship exists, where a sub-body does the legwork and then presents its fruits to the mother body, so to speak?
Justice Sutherland, I don't know that there is a clear answer, but our submission would be that it's likely the latter. And that kind of scheme, to use your terminology, the mother body and the sub body, is by no means unknown in other contexts in our law. For example, what used to be called the Board on Tariffs and Trade, now the International, I'm not sure what the current name is. It used to conduct investigations. It would report to the Board of Tariffs and Trade, and a final decision would then be taken by a minister. So that kind of hierarchical scheme is by no means unknown. And so we would be content with the mother body type analogy. The only point of law, I suppose, that we would make is that in such a relationship, one cannot lose sight of the different functions performed by the trial court, which would be the tribunal on the one hand, and the JSC on the other. And the only point we would make in that context is really a trite point, and that is the mother body, in this case the JSC, would be deferential to the findings of fact made by the tribunal, who has all the advantages enjoyed by a trial court. So it's really an argument about deference more than anything else.
Thank you. Thank you, JP.
Judge Victor? You're muted.
Just thank you for the very, very helpful cross-tabulation of all those references.
Okay. Yeah.
Thank you, Justice Victor.
Thank you very much, Advocate Marcus. I don't have questions. I'll suggest that we adjourn for 10 minutes, stretch our legs, and then thereafter we'll hear arguments of full. They indicated that they'll take about 1 hour.
Thank you.
If you can adjust for 10 minutes, we'll start at 3:30. Thank you.
Thank you.
Canadian ethical principles for judges. But if you don't, would it be in order that if we simply took steps to upload them on case lines and to inform your registrar that we have done so?
Yeah, I think that will be in order.
Thank you, my lord.
Yes, thank you very much. Advocate Du Plessis, you ready?
Yes, thank you very much, Deputy Judge President.
You may proceed.
I'm just double checking that I see Judge Sutherland.
BJP sub.
We
We are a minute early.
are a minute late.
You see, mine says early.
Okay, I think maybe let's just check. I hope what happened yesterday will not occur today.
No. I think, JP, do you want me to phone him?
Oh, yeah, it is it.
Sorry.
Thank you.
Thank you. If I may then begin, thank you very much. Thank you, Justice.
Yes, you may proceed.
Given the time of day, if I might just jump directly in. We, of course, do not, for freedom under law, want to repeat what the other respondents have already said. And so with the time left for me, our intention is to add what we regard as additional points in support of why the review must fail. And I intend to do so with the court's leave under two broad chapters. The first is through a discussion of what we say are three critical governing principles applicable to this review in this context. Some of those principles have been touched on by our learned friends, but we wish to go into them slightly more deeply. And secondly, I would wish to give a discussion of why it's inappropriate for Judge Hlophe to constantly invoke the 2009 JSC decision as some form of past testament to his innocence. And we respectfully submit that Full is well placed to make that argument, because it was, after all, Full's case that came before the SCA in 2011 in the judgment by Streicher JA that set aside that 2009 JSC decision. So those are the two broad chapters which we wish to give some comment on. So let me start with the governing principles, if I may. Having listened to the argument, we think it's helpful to draw attention to three governing principles that we say respectfully require close adherence in this matter. And they are framing principles, and they're drawn from the Constitutional Courts and the Supreme Court of Appeals jurisprudence. And they've been helpfully collected and reflected upon in the new edition of Professor Hoekster's leading book on administrative law of 2021, a book now by Hoekster and Penfold. And I've drawn attention to our learned friends that we would be referencing two additional pages from Hoekster's book before this argument commenced, so that they are well aware of it. They are not in our heads, but they are of great assistance, we say, with respect to the court, and I'll reference them in a moment. Those principles confirm, we say, that Judge Hlophe has significant hurdles to succeeding on each of his attacks, on his efforts to re-argue and have the merits re-decided, by his belated claims of bias and continuing his attacks on his accusers, and by what we regard as his fault-finding approach to the composition of the JSC and his efforts to restart this entire saga before the National Assembly. And we've listened to his argument, but in respect of each of those attacks, we say with respect that our learned friends have not paid heed to three governing principles applicable to this case. They are these. The first is the principle of the intensity of judicial review, what Hoekster calls the intensity of judicial review, or the respect or deference for the interpretations of law and fact of a constitutional ordained body like the JSC. The second principle is a principle which is heightened for judges, and that's not to become accusers of their accusers. And the third principle is the principle of finality, a principle that screams out for finality in this case, if you'll forgive me the pun. Before I come to those three principles, we think with respect that it may be valuable to be reminded of the case before this court, and because the passage of time and revisionist attempts at history, we say, should not have inured anyone, including the public, to the nature of the complaint against Judge Hlophe. And with respect, we've listened to what Mr. Marcus has had to say, and a number of the references to how the Constitutional Court judges themselves have viewed the complaint. But we'd add one further reference, and that is how the Constitutional Court justices perceived the nature of the threat that had been made against them and the authenticity of the complaint as it had been relayed to them by their colleagues. And that's put by Chief Justice Lange, and it's at case lines 001-508. And with respect, it's a very important passage. It's 001-508, and it's paragraph 5.3, and it's by Chief Justice Lange in his statement in response to the complaint to the JSC by Hlophe JP that was made on the 10th of June 2008. And this is what Chief Justice Lange said on behalf of the court. He said, speaking about the approach that had been made by Judge President Hlophe to Justices Jafta and Nkabende, he said, the other judges were shocked and distressed by the reports. None of the judges had experienced such a serious affront to the integrity of the judicial process in their careers as judges, and the matter was accordingly viewed in the gravest possible light. Importantly, he goes on, he says, in the absence of any possible reason to suggest that our colleagues would manufacture reports of such a serious nature, we accepted the accuracy and the veracity of what they had been told and continue to do so. So we commend that with respect to the court right at the outset because it confirms three things we say. The first is this: that's how our country's highest and most respected jurists perceive the nature of the threat and on the common cause facts, including with respect the premeditation that Mr. Marcus spoke about earlier, and which, as he pointed out, was not contested under cross-examination. So that's how our justices perceived the nature of the threat. And secondly, they were well aware of what Mr. Masuku, our learned friend, repeatedly stressed yesterday, which is the presumption of judicial integrity. But they perceived the common cause facts in a way as a direct threat to the court. And even assuming that the presumption applied, they accepted that the presumption clearly had been rebutted because Judge President Hlophe's conduct was in and of itself, by its nature, destructive of that very presumption. And the third thing that it confirms is that Mr. Masuku, our learned friend, is quite wrong with respect to him to repeatedly contend for Judge Hlophe's subjective intention, and that Judge Hlophe did not intend to influence the Constitutional Court justices, and to proffer, as he did yesterday, energetic examples of how advocates and judges, in his experience, talk about cases. It's quite wrong because the test is an objective one. So when Mr. Masuku says, and these were his words, if I wrote them down correctly, he said, a reasonable person witnessing their conversations would not find anything untoward. Well, with respect, that ignores that a reasonable person would consider how the justices themselves perceived this approach. That is a critical contextual factor. This is not just one discussion between justices and a judge who approached them. This is also how justices who had this reported to them believed that this was improper. And that is a critical contextual factor which would play a very serious role in this context. And so the fundamental problem with Mr. Masuku and our learned friend Mr. Donan's approach is that it ignores public perception. Mr. Donan struggled to articulate when on the sliding scale the conduct would reach what he called the plateau of gross misconduct. And with respect to him, the best he could do under questioning from the court was to say, well, the judges were at liberty to write their own judgments. So they were still at liberty to write their own judgments because Judge President Hlophe hadn't actually threatened or forced them to write one way or the other, and the attempt failed. But with respect, that of course ignores public perception about what took place here. You can test that easily. If Judge President Hlophe had left a large sum of money on the desks of either of the justices, they would also still have been at liberty to write their judgments one way or the other. It would have been up to them as to whether they decided to take the money or not. But that's not the question. The question is, what would the public have perceived about that approach and the leaving of the money, even if it was open to them still to decide how they wrote their judgments? The public, with respect, would be aghast at the attempt, and that they would clearly see as an improper attempt. The second problem with that approach by learned friends is that it tries to make the plateau of gross misconduct one of actual interference. But as Mr. Maleka, our learned friend, pointed out for the JSC, that misunderstands the complaint. The complaint wasn't about actual interference. It was about an attempt to influence, an improper attempt. And as Mr. Marcus pointed out, that sets the bar wrong. It sets it impermissibly low as something which clearly would be in Judge President Hlophe's favor, but which is not the test and not the way in which the complaint was framed. And as Justice Sutherland pointed out, the JSC was engaged in a value judgment, and it was rational for them to decide that interference entailed improper influence. And I'll get to whether the court can interfere with that understanding in a moment, but the simple point is, as Justice Sutherland with respect pointed out, the test is whether it was rational for this body to decide that interference might entail improper influence, including an attempt rather than a completed threat. And we know it's rational with respect for the JSC to have done so because of the freedom under law judgment, which is at case lines 001232, paragraph 50. At paragraph 50, the SCA says the following, and it has been referenced by some of our learned friends, but it's worthwhile highlighting again here, because here the court describes the very issues that the Constitutional Court justices were confronted with, and the court describes what the JSC was going to have to interrogate. And the SCA says at paragraph 50, case lines 001232, any attempt by an outsider to improperly influence a pending judgment, not to interfere with, not to make a threat at, not to complete a threat. It says any attempt by an outsider to improperly influence a pending judgment of a court constitutes a threat to the independence, impartiality, dignity, and effectiveness of that court. And so in the SCA's own words, they provided the guidance that the JSC needed. Their plateau, to use our learned friend Mr. Donan's expression, was clearly defined by the SCA at that paragraph, and the JSC then did its duty once the matter had been referred back to it. So if I might then, after that preface, turn to the three principles which we say are of particular application in this case. And I can be, I hope, relatively brief on some of them. The first principle goes to the question of the merits, and the principle is one of judicial restraint or deference. And we've, in numbers of our heads, the respondents you'll have seen, have cautioned that Judge Hlophe's case is an appeal dressed in review's clothing, and that he attempts to have this court second-guess the merits. All of the respondents have highlighted that danger, but why? Well, in our respectful view, that's because of a deeper principle, and that is that the JSC's decision is due deference. It relates to what Justice Sutherland, with respect, put to our learned friends when I think he asked that he was interested to examine the substantive platform of the review. Well, precisely, with respect. It's obviously the case that the platform of this review needs to be set correctly for three reasons confirmed by the Constitutional Court and specific to the context of this case. The first reason for deference is because this is a specialist tribunal. It's the JSC's misconduct panel, constituted specifically to investigate the merits. Our learned friend, Mr. Donan, quite correctly said that the process involved a removal process in which the JSC, and his words were, makes findings of law and fact. Well, quite so. As our courts have repeatedly said, including the Constitutional Court in Batterstar, our courts, as a matter of course, must show deference to the findings of fact and law of specialist administrative bodies. In this case, the Judicial Conduct Tribunal heard evidence and debates over 5 days. I think my learned friend, Mr. Marcus, confirmed for me when I asked him how many days they'd been there. It saw the witnesses firsthand. It thereafter considered the report. It gave a reasoned explanation as the mother body, as Justice Sutherland put it, having considered what the sub-body had investigated. It gave a reasoned explanation through a majority and a minority decision for why it was going to accept the Judicial Conduct Tribunal's findings of fact and law, and ultimately why it believed that Judge Hlophe was guilty of judicial misconduct. And accordingly, the decision of Mlambo JP that has been cited in Freedom Under Law's heads is particularly of importance. It's at paragraph 106 of Fool's heads. It's at case lines 015-346. And it's Mlambo JP in the case of Somali Association of South Africa versus the Refugee Appeal Board and others. You'll see it cited there. I'll simply lift out the 3 points that he makes at paragraph 40 and 47, cited in our heads at paragraph 106. He says it's necessary to restate the key principles applicable in reviews. It must be emphasized at the outset that the overriding principle in review applications is that courts must show deference to entities created to perform specific and specialist functions when reviewing their decisions. He says courts should not substitute their opinions for those of tribunals. He goes on at paragraph 47 to say it's clear in the submission of the applicants they seek to have the RAB determinations reviewed and set aside as they're wrong. But he says that's not an acceptable yardstick. It's not open for courts of law when hearing review applications against administrative action to position themselves as umpires of what's right or wrong about the administrative action at stake. He says this cannot be countenanced within the framework of our constitution. So we've referenced for you the Somali Association case, but we'd like to draw attention further to the discussion in Professor Hoekster's updated book on administrative law of 2021. More generally, we commend to the court the discussion at page 178 onwards, where Professor Hoekster speaks under the heading 3.4. She speaks at page 178 onwards under that heading of what she calls the proper extent of judicial review, justiciability, deference, and respect. And in that discussion, what is particularly helpful is the attention that she gives to the Constitutional Court's decision in Bapedi Maroto Mamone versus Commission on Traditional Leadership Disputes and Claims. It's a case which she cites, and it's a case for your citations benefit. It's 2015, volume 3, BCLR 268CC. And the case is of obvious analogous importance with respect. It deals with the rationality of a decision of the Commission on Traditional Leadership Disputes. A commission like the JSC, it had investigative powers. It was specifically set up to investigate, as its title suggests, leadership disputes. And in that case, it was investigating a leadership dispute as to the rightful king of the Bapedi traditional community. As Hoekster points out in her book at page 201, she says the majority judgment, which was written by Justice Kimpepe, helpfully located its analysis within the context of deference. The court emphasized the need to treat the decision with appropriate respect, particularly because of the wealth and complexity of the factual evidence it had gathered and considered, and the special expertise of the commission. And she points out, does Professor Hoekster, that the impact of deference is best seen by comparing the majority and the minority judgments in Bapedi. And she notes the criticism by the majority of the minority judgment for having adopted an approach that the majority said was not relatively deferential. Importantly, this court will in its own time, I shan't take the court through the paragraphs in detail, but in reading the Constitutional Court's judgment, the court will see that with respect, it puts an end to Judge Hlophe's case. At paragraph 78 of the judgment, the Constitutional Court says this: before considering the factual basis for the applicant's contentions, it's necessary to sound a note of caution. Our right to just administrative action and PADJA require rigorous scrutiny of administrative decisions. And then she says, but neither asks courts to substitute their opinions for those of administrative bodies. It's not required that a decision of an administrative body be perfect, or in the court's estimation, the best decision on the facts, a point that Justice Sutherland raised with one of our learned friends. The court goes on at paragraph 81. This case involves an investigation that ran over 2 years. It covered a wealth of material. It included a series of hearings in which the applicant participated extensively. After these hearings, the commission conducted its own research. It then drafted preliminary statements which it put to the families. Both families commented on these in writing. You'll see the analogues as I say this. Thereafter, they attended a hearing where again they were heard, and the commission produced a 40-page report some months later. Says the Constitutional Court at paragraph 91, the applicant invited us at the hearing to understand these facts differently. It's exactly the invitation that you've received from our learned friends. understand the facts differently. But, said the Constitutional Court at paragraph 92, even if we were persuaded by this argument, it misses the point of rationality review. That we could interpret the facts differently to the Commission does not, especially given the respect we must show to its findings in this context, entitle us to set aside its decision. And so the court dismissed each of the rationality challenges. And the court did so by an understanding of deference. And as I say, it criticized the minority for adopting an approach different to that, which was not relatively deferential. So that's the first point in favor of deference. It's the Bapedi judgment of the Constitutional Court. The second reason for deference, Justices, is a related one, and it's the strict law on review for mistakes of facts. It's the strict law on review for mistakes of facts. In our heads, for freedom under law, at paragraph 117, that's case lines 015-351. We've drawn attention to the case of Dumani versus Naya. It's an SCA decision. And as we pointed out, the case bears many similarities also with this case, because there the Magistrates Commission had appointed a presiding officer to hold a disciplinary inquiry into charges of misconduct against a magistrate, Mr. Dumani. After having heard that evidence, Mr. Dumani was found guilty of misconduct and recommended to the Magistrates Commission that he should be removed from office as a magistrate. And the Magistrates Commission then, like the JSC here, resolved to accept that recommendation, and it was challenged by Mr. Dumani on similar grounds to Judge President Hlophe's challenge in this court. And this is the point, as we stressed in our heads there, the SCA would have none of it, because as we quoted paragraph 116, the SCA said, in our law, where the power to make findings of fact is conferred on a particular functionary, an administrator as defined in Padgett, the material error of fact ground of review does not entitle a reviewing court to reconsider the matter afresh. And this is critically important because Judge Hlophe's entire case on the merits is to quibble with the JSC and to say that they got the facts wrong and they came to the wrong conclusion about his efforts to influence Justices Jafta and Nkabinde, and that they misunderstood the test for gross misconduct. But here too, with respect, our learned friend's case does not, in fact, leave the starting blocks. And that again has been made clear by Hoekstra. And on this occasion, at page 425 of Hoekstra's textbook, Professor Hoekstra cites Judge Unterhalter's, by now, with respect to him, already famous decision in AXA versus Twelachotso Trading. AXA versus Twelachotso Trading, which she cites, and which she points out has been subsequently approved by the SCA. What did Judge Unterhalter say there? Well, he summarized the current state of the law as to when a court may interfere when a functionary like the JSC here exercises a competence to decide facts. And Unterhalter J said the following, quoted, as I say, by Professor Hoekstra at page 425. He said, the exercise of judgment by the functionary in considering the facts, and then critically, such as the assessment of contested evidence or the weighing of evidence, exactly what the JSC was doing, is not reviewable, says Judge Unterhalter, even if the court would have reached a different view on these matters were it vested with original competence to find the facts. So that's the second reason for deference. Mistakes of fact, which is effectively the heart of Judge Hlophe's complaints against the JSC on the merits, are not reviewable by a court, precisely where the functionary in considering those facts was engaged in the assessment of contested evidence or the weighing of evidence, quite obviously what was happening in this matter. The third reason for deference is the following. The decision to find Judge Hlophe guilty of gross misconduct was not taken by some ad hoc body. It was the decision taken by the very body tasked by our constitutional scheme for removing judges after an exhaustively fair process. And critically here, in the process of coming to those decisions, it had to exercise two value judgments that the Constitution entrusted to the JSC. It's critical with respect to recognize that those are value judgments. And again, Justice Sutherland, I think, correctly pointed out to our learned friends, I think, for the BLA, that this is a case about value judgments being made. The quote in question is the SCA's decision in Lange versus Hlophe. It's at paragraph 18 of Freedom Under Law's heads, case lines 15-317. And it's a critical quote because the SCA there describes the role of the JSC as a constitutional one and its function in the disciplining of judges. And at paragraph 23 is the critical quote. The SCA says, the JSC is under the Constitution, the forum for deciding whether or not a judge is guilty of gross misconduct. Such a conclusion presupposes a finding that the judge committed the conduct complained of. And then you see the important paragraph, which may involve factual or legal findings. Then says the court, the JSC may find that the complaint is without merit and summarily dismiss it. If it has merit, here's the next critical paragraph, 2 value judgments follow. Did the conduct amount to misconduct? And if so, was it gross? And I stress that with respect, Justices, because that is precisely the heartland where you're dealing with value judgments by an administrative body tasked with taking decisions that a court will show deference to those value judgments. It's not whether you think your value judgment or decision would be different to the JSC. That's not the test. They are entitled to make their value judgments as to whether there was misconduct and gross misconduct, and it was within their constitutional province to do so. And critically, aside from his belated claims of bias, Judge Hlophe has not challenged the process as being unfair. He doesn't say that his procedural rights were violated. He cannot credibly do so, because in fact, he himself refers to the process before the tribunal in the following terms in his finding affidavit at paragraph 127. At page 001-62, where he says that the process entails, in his words, or entailed rather, in his words, a full ventilation of the matter. And the JSC in its heads at paragraph 66-74 has set out the various steps that it followed to ensure fairness. So he had a full and a fair hearing, and by that full and a fair hearing, the JSC tribunal came to its value judgments on the merits. And the Constitution entrusted those value judgments to it and it only. And so instead of any deference to those processes or the decision, Judge Hlophe now enlists you judges. He enlists this court's aid in not only neutering the JSC and its findings, but potentially bypassing it altogether by suggesting that the case should go to the National Assembly. We know that he's attempted to do so from his remedy. According to him, the tribunal and the JSC's decision should be undone, and Judge Hlophe should be permitted to bypass the JSC and have the politicians in Parliament decide his fate. But that would be at variance with the very constitutional scheme that has been prescribed. And it would then, if he were correct on his remedy, it would be without the benefit of the report of the specialist tribunal under the Constitution that has been written in respect of the very gross misconduct that it is tasked with deciding on. And so we say with respect, this court will bristle at that attempt too, and will show deference to the constitutional scheme, because the Constitution has directed that the JSC is the specialist body that determines these issues. It has done so, as I've said, and the correct opportunity for Judge Hlophe to convince anyone that he should not now be impeached lies ahead under the constitutional scheme with the National Assembly. So that's the first principle. And that is the principle of not unduly interposing with respect in the garb of a review at the carefully arrived at findings of the JSC. The second principle is the following, and it goes directly to the repeated claims of bias by Judge Hlophe. And that principle is that it is a duty not to accuse one's accusers. I can say less on this than I had originally thought to say, because Mr. Marcus has already covered some of this ground. But if I might draw attention to the following points. According to the SCA, through the Mohami case that Mr. Marcus highlighted, the judgment of Harams JA, it is not permissible, it is unprofessional conduct to accuse one's accusers. And the history here is not edifying. You've already seen how he has criticized, President Hlophe rather, has been criticized by the Judicial Conduct Tribunal for breaking down the institution and accusing the accusers. You'll see them having said that at case lines 000-189 at paragraph 35. So he's already been criticized by the Judicial Conduct Tribunal for this very unprofessional conduct highlighted by the SCA. But in this case, Judge Hlophe now argues that when the JSC deprecated him for doing so, the JSC then acted in a biased fashion against him. So despite the Judicial Conduct Tribunal and the JSC majority having admonished him for this tactic, he now persists in doing so in this court. He now claims all manner of bias against Justices Kampepe, Mlambo, and others. But here's the simple point. Given that this is of a piece with his previous attacks on the Constitutional Court justices as his accusers, the allegations of bias against the JSC in this court must be viewed not only with skepticism, but with respect opprobrium. That's not only because this is a practice that he's previously adopted and been criticized for. It's also because how can a practice which is unprofessional, according to the Mohami judgment in the SCA, how can a practice which is unprofessional be reasonable? The test is whether he holds a reasonable apprehension of bias. But by virtue of his conduct and the strategy that he has adopted, we know that the SCA has already described that as unprofessional, so it cannot be reasonable. And this court then, when considering the bias claims and whether they're reasonable or not, will hold Justice Hlophe with respect to a high standard. He's not an ordinary litigant. The attacks, as the Constitutional Court justices have pointed out in their heads, were undoubtedly calculated to seriously stain the image and reputation of our courts. And his bias claims, therefore, must be seen in that light. And they are therefore unreasonable, to put it lightly. They are not the claims made by someone who reasonably suspects bias. They are claims of someone who has shown a pattern of accusing his accusers, and in that context, an unreasonably self-serving accusation too. Our learned friend, Mr. Marcus, let me finish on this point, referenced the judgment of Lord Denning in the case of Moran, which, as he highlighted quite correctly, has already achieved approval by the SCA in this very case in Lange versus Hlophe. But one bears reminding of what was said by Lord Denning then, because it puts in context again how unreasonable it is for Judge Hlophe to have acted in the fashion that he has in his accusations of bias and his suggestions that the Constitutional Court justices have fabricated a complaint against him. Lord Denning said, "We often find that a man who fears the worst turns around and accuses those who hold a preliminary inquiry of misconduct or unfairness or bias or want of natural justice. He seeks to stop the impending charge against him. It's easy enough for him to make such an accusation. Once made, it has to be answered. So he says there's a triable issue and that it must go to trial. He knows it will take months and months. So he gets that which he most wants, time. Time to make his dispositions, time to hit off the day when he has to meet the charge. And who knows, if he can stop the preliminary inquiry in its tracks, it may never start up again." That is at case lines 014-43. And says Lord Denning, "To my mind, the law should not permit such tactics. They should be stopped at the outset." The third principle that we say weighs in this case is the public interest in finality. With respect to our learned friends, if there was ever a case calling out for the merits already determined to be regarded now as final, it is this case. The SCA in Nkabinda, the judgment by His Lordship Mr. Justice Nafsa, which has been referred to by numbers of us, it's, if I may give the citation, it's 2016, volume 4, essay 1, SCA. I couldn't find it in case lines, so you'll forgive me, I've just given you the reference. But at paragraph 104, Justice Nafsa said this. He said, "It was unsettling when counsel on behalf of the appellant with emphatic certainty stated during submissions before us that this matter would never end, speculating without specificity that there would be ongoing challenges to proceedings related to the complaint." And then importantly, said Justice Nafsa, "The judicial image in South Africa cannot afford to be further tarnished in this manner. As can be seen from the extensive litigation referred to above, each of the protagonists, including the JSC, has contributed to the delay. There must be now a concerted effort and determination on the part of everyone concerned for the matter finally to be put to rest." That principle has been expressed by the SCA. In that case, it's also been expressed by His Lordship Justice Streicher, as you know, in the 2011 Freedom Under Law judgment. But Judge Hlophe rather does not want finality. He wants a restart. He wants a restart. And the principle of finality here, we say, must weigh very heavily against his efforts at a restart in three ways. Firstly, it must weigh very heavily against the formalistic point taking We've seen how Judge Hlophe has raised multiple technical and procedural points on composition and the like. Those have been dealt with. I'm not going to say anything more about them. But the point is a straightforward one. Instead of asking whether the case against him has been exhaustively run by the JSC that allowed the substance of the complaint to be weighed and assessed, we have seen how Judge Hlophe and his legal team have adopted very firmly the cape of formalism. They approach every feature and every person involved in the case in a fault-finding spirit. But with respect, all of these formal complaints don't allow the substance of the dispute, which has already been determined finally by the JSC, to move to its constitutional province in the National Assembly. The second reason finality weighs heavily in this case is that it weighs heavily on the question of remedy. Firstly, as our learned friends for the JSC have said, even if you were in some other way to find that there was a composition fault, even if you were, finality requires a remedial outcome that is just and equitable in this case, which allows the matter on the substance to remain intact and to move forward on the understanding that Judge President Hlophe has been found guilty of gross misconduct. It also weighs very heavily on remedy in another way. It weighs very, very heavily as a principle of finality against the type of remedy that Judge President Hlophe seeks. Because as I've said, by his relief, Judge President Hlophe wants it to be year zero all over again. But he wants an advantage. He wants a clean slate by setting aside the report of the tribunal, giving him an unblemished chance then at his exoneration before the National Assembly. But that would be a restart going nowhere quickly. Our learned friend Mr. Masuku said that when this case and the complaint started, he was 5 years at the bar. I think he says he's now been 19 years at the bar. Well, with respect, he then also, I think, jocularly, he said, well, this case is going to take even longer if the matter goes back to the JSC. But with respect, don't think that it's going to take any longer if it goes to the National Assembly, according to our learned friends. As we pointed out in our heads of argument at paragraph 136, case lines 015-357, page CL 015-357, it's paragraph 136. Judge Hlophe has given the game away in respect of his strategy at the National Assembly. You'll recall, as we pointed out there in our heads, Judge Hlophe approached this court urgently in Part A of the proceedings, complaining that the matter should not proceed to the National Assembly because he said no rules had yet been adopted to regulate the removal process. And there was, according to him, no telling how long the matter would languish before the National Assembly, should urgent relief not be granted in his favor. He characterized the National Assembly process as being of indefinite duration. Those were his words. He said it would be of indefinite duration before the National Assembly. So judicial integrity with respect already corroded with further suffer. Judge Hlophe does not offer to stand down from his position as Judge President while the parliamentary process begins all over again for what he calls indefinite duration. His purpose would be achieved, delaying the conclusion of this decades-long matter and escaping the JSC scrutiny. And so the principle of finality, we say, weighs very heavily against his relief as well. The need for finality with respect to the court is now on the merits even more pressing for three short reasons. First, not only have 5 further years passed since the Constitutional Court in Nkabinde wrote that this case must now be brought to finality. You'll recall in Freedom Under Law's heads, at paragraph 11, we quoted the Constitutional Court in Nkabinde, who 5.5 years ago said that the events that gave rise to this complaint have to be finalized. It's in the interests of justice that this matter be brought to finality. So it's not just that 5.5 years have passed since the Constitutional Court wrote those words. In those 5.5 years, the JSC has reached a decision on the value-based judgments it had to, that Judge President Hlophe is guilty of gross misconduct. Secondly, with each passing day that the JSC's decision is not implemented through that constitutional scheme that I've spoken about, that allows the National Assembly now to consider the report, judicial integrity is further damaged because a judge president who has had a finding against him of gross judicial misconduct, who refuses to step down and who constantly litigates in the courts, stays in office. And third, and whilst in office, as Mr. Marcus, our learned friend, pointed out, he continues to attack his accusers, including in this very court, including senior judicial officers, suggesting that they have fabricated a complaint against him, something that he has not withdrawn and persists in saying. So if I might conclude on the framing principles and then very briefly move to the 2009 JSC decision as my second chapter, but concluding on the framing principles, we say these three principles of deference, respect for one's colleagues rather than accusing them, and finality, we say govern this case, and they do so on high authority of the Constitutional Court and the SCA. As we've explained, Judge Hlophe wants to torpedo those principles. He wants this court to trawl the evidence and come to a second guessing and a different view to the JSC on the merits, but our courts have stressed that that is not permissible. He wants to further disrespect the constitution scheme of the JSC and the National Assembly by enlisting this court's aid to bypass the JSC and render him directly unto the National Assembly for what he himself describes as an indefinite duration. But that would obviously subvert the constitutional scheme for removal of judges, and it would blow the principle of finality right out of the water. And while all this takes place, all the while this takes place, this subversion of our constitutional court's jurisprudence and our constitution scheme, Judge Hlophe would continue sitting as a judge with no finality over this process, an outcome that we say is in direct contrast with the public interest, given that he has, as I've stressed, been found guilty of gross misconduct. So accordingly, in that light, Judge Hlophe's case should be very carefully scrutinized, we say, through the light of those framing or governing principles. And when that is done, all that's really left of his case are two arguments. The first is that somehow, because the JSC in 2009 exonerated him, he cannot be condemned by the JSC now. And the second is to raise a multitude of procedural and practical challenges to the composition of the JSC, which our learned friends for the JSC have already dealt with. If I might then turn briefly, and I see that I've got just 10 minutes left, to the 2009 JSC decision and the procedural complaints, because those, as I say, are called in aid by the Judge President, and we say quite incorrectly or inappropriately so. A repeated refrain by Judge Hlophe is to cling to the 2009 JSC decision as some form of past testament to his innocence. He time and again says that since the JSC in 2009 found that he was not guilty of gross misconduct, there is some unconstitutionality or suspicious conduct for the JSC now to have done so in 2021. And his argument starts early in the first substantive paragraph of his papers, in the finding affidavit at paragraph 2, case lines 001-12. So in his opening substantive paragraph, he says, in 2009, I was found not guilty of gross judicial misconduct by the JSC in a well-considered ruling that accurately considered the evidence and applied the correct legal standard. I stress, he says, that accurately considered the evidence and applied the correct legal standard. He goes on in that same paragraph to say that 12 years since the JSC made that finding, the same JSC, on the same facts and evidence considered by the JSC in 2009, found me guilty of gross judicial misconduct by a majority of its members. I stress, he says, on the same facts and evidence considered by the JSC in 2009. He warms to that theme you'll see in his supplementary finding affidavit at case lines 001-606, paragraph 9. 001-606, paragraph 9. He suggests that there's something constitutionally fishy. Why the majority of members in the JSC in 2021 and the tribunal, he says, without any new and or better evidence about my alleged misconduct, reached conclusions that were so vastly different to the JSC, which on substantially the same evidence exonerated me. Again, he says, as I stressed, without any new and better evidence, it's substantially the same evidence. And you can see, I don't have the time to take you to it, but you'll see that his attorney, Mr. Tulu, has continued this line. There's a media release on behalf of the Judge President, which you'll see at case lines 001-561, where he says the same thing effectively at paragraph 8, stressing that 2009 he was exonerated, and how can it be that in 2021 he's found guilty? But the argument, we say, is built on two palpably false premises. First, that the 2009 JSC decision accurately considered the evidence and applied the correct legal standard, to use his phrase. And secondly, that the 2021 decision was arrived at on substantially the same evidence as the 2009 decision and without any new and or better evidence. Well, it's a false premise because the 2009 decision was set aside by the SCA, precisely because the JSC in 2009 did not have all the evidence before it, because it had expressly refused to allow cross-examination, the court will recall. And in doing so, it had not accurately considered the evidence or applied the correct legal standard. You will see that palpably from His Lordship Justice Streicher's decision. It's in case lines 001230 at paragraph 31 of the SCA's decision. He says, at the hearing in April 2009, the complainant's evidence was not tested by cross-examination, as Hlophe JP and his legal representatives were not present or represented. The interviews conducted on 30 July 2009 were submitted by the applicants brief and perfunctory. They consisted of the confirmation of the correctness of the evidence given at the hearing in April 29 and questions by the 3 members of the subcommittee. No cross-examination was allowed. The JSC was therefore confronted with the untested evidence of Jafta AJ and Nkabinda J on the one hand and the untested evidence of Hlophe JP on the other hand. And so the evidence, my lords and my lady, was patently unlike the evidence led over 5 days before the 2021 tribunal. As directed by the SCA in the full decision, in the 2021 tribunal hearing, the tribunal heard oral evidence and permitted cross-examination. The critical oral evidence was presented by Justices Jafta and Nkabinda as well as Judge President Hlophe. And the tribunal also had before it a vast amount of documentary evidence, which was confirmed on oath by the respective witnesses during the tribunal hearing. And so it was on the strength of all the evidence, both documentary and oral, that the tribunal reached its ultimate conclusion. Then importantly, one needs to read paragraph 41 and 42 of the SCA's decision. And that is to be found if one wishes to see it at case lines 001-231. There the SCA said, the JSC concluded that the evidence of Jafta AJ standing alone was not sufficient to establish that Hlophe JP attempted improperly to influence him to decide the Zuma matters in a particular way. In regard to the evidence of Nkabinda, the JSC pointed out that there were contradictions between her evidence and that of Hlophe JP and said that the question arose whether her evidence was material. Dealing with this issue, the JSC said that the evidence contradicted by Hlophe JP did not appear to have a material bearing on the central question that it was required to consider, namely, did Hlophe JP attempt to improperly influence Nkabinda J to give judgment in a particular way against her conscience or better judgment? And then critically, paragraph 42, the SCA says, this finding by the JSC is irrational. Hlophe JP contradicted almost everything that Nkabinda J said. It follows that the JSC considered virtually everything that Nkabinda J said, virtually everything on the strength of which she drew the inference that Hlophe J tried to influence her, to be immaterial in respect of the question whether he tried to influence her. It cannot conceivably, rationally be considered to be immaterial, said the SCA, to the question whether Hlophe JP tried to influence Nkabinda. And you can read the rest of that paragraph for your own. So clearly, the JSC did not accurately consider the evidence, to use Judge President Hlophe's phrase. On the contrary, it did so, according to the SCA, irrationally. And so it was not set aside on the basis of a technicality, as Mr. Kulu says in his media report for the Judge President. It was set aside because the merits of its findings were irrational. And then at paragraph 44 and the concluding line of paragraph 45 of the SCA decision, you'll see that the SCA says the following. You'll see it in the last paragraph of paragraph 44. It says it follows that the JSC applied the criminal standard applicable at the end of a criminal trial, namely proof beyond reasonable doubt, to dismiss the complaint at a stage when neither of the conflicting versions of the two judges on the one hand and Hlophe JP on the other had been tested by cross-examination. And then you'll see at paragraph 45, it continues to discuss that. And at the end of that paragraph, the SCA says, the procedure adopted was therefore not appropriate for the final determination of the complaint. And so clearly, the JSC did not apply the correct legal standard. On the contrary, it got the law totally wrong, according to the SCA. It applied the wrong test. And so finally, one can read paragraph 47 and 48 of the SCA decision. There, the SCA said the JSC purported to justify their decision to dismiss the complaint without proceeding to a formal inquiry by saying that cross-examination would serve no purpose, and an advanced number of reasons in support of its view, The SCA then lists each of those reasons. I shan't read them for you. But at the end of that, it comes at paragraph 48 in response to the JSC. And it says, I find the reasoning surprising. Courts frequently have to decide where the truth lies between two conflicting versions. They often do so where there's only the word of one witness against another, and neither of the witnesses concedes the version of the other. Says the court, civil cases are decided on a balance of probabilities, but where there is a dispute of fact, it's rarely possible to do so without subjecting parties to cross-examination. The court concludes, a court may, of course, after cross-examination, still be unable to decide where the truth lies, but that possibility does not entitle a court to decide the matter without allowing cross-examination, and it does not entitle the JSC to do so in this case. And so clearly then, the JSC failed to properly interrogate the case because it didn't test Judge Hlophe's versions under cross-examination. The result, my lords and my lady, is that the 2009 decision is nothing like the 2021 decision. It was a false start. It didn't interrogate the versions. It applied the wrong criminal test. It acted irrationally, said the SCA, as regards the evidence. And with respect, it's simply impossible to understand how the judge president could, in the face of those palpable differences and constitutional defects and irrationalities, suggest that the 2009 decision is some form of exoneration of him, or that it is a basis to throw darts at the 2021 decision. And not only does he fondly embrace the 2009 decision on the basis of these false premises, he does so with respect to our learned friends, but disrespectfully ignoring the fact that this is a decision of the SCA. As the judge president, it's simply not open to him to cling to the 2009 report as some form of past declamation to his innocence. The SCA has spoken finally on the defects in that report, and its views are binding on him as much as they are on me and on this court. And it's a discourtesy with respect to the SCA to make as though it hasn't dealt with that report in close detail, as I've highlighted for the court, and its findings. And then there's finally the obvious point, and that is that the SCA do not only critically undo the findings of the JSC in 2009, it set aside its central conclusion. It did so in a remedy directed specifically at the JSC's 2009 decision. You'll see the order of the SCA at paragraph 65 at case lines 001-233. It said this in its order, having highlighted all of these errors. It said, the decision of the JSC at its meeting on 15 August 2009, that the evidence in respect of the complaint does not verify a finding that Hlophe JP is guilty of gross misconduct, and that the matter accordingly be treated as finalized, is reviewed and set aside. And so, on this entire basis, it is with respect inappropriate for our learned friends repeatedly to invoke the ghost of 2009 past, so to speak, in an effort to try and cast, firstly, the judge president in an innocent light, and secondly, to use that as a basis to criticize a very different and much more thoroughgoing process that the JSC in 2021 followed. The 2009 report is a nullity. It has no legal existence, and Judge Hlophe's repeated invocation of that legally stillborn report does not give it life. Those are our submissions, judges, or justices, I should say, subject, of course, to any questions that you have. I appreciate that it's late in the day.
Okay. DJP Sutherland.
Thank you. Thank you.
I do. Mr. GP, I want to just take you back to composition. I know that you haven't argued it because it's been thoroughly argued by Mr. Ngukatoibi. But in your heads of argument, paragraph 45, you urge on the court to take into account delegation.
Yes.
And that it's a characteristic, as Cora Hoekstra says, it's a characteristic of modern government.
Yes.
Is that still something that you persist with in terms of the composition analysis?
We do. We stand by every point we've made in respect of composition on the heads of argument, and certainly we see that as a particularly helpful understanding of there are two approaches as we've seen the argument develop. Our learned friends on composition for Judge President Hlophe repeatedly make what we would describe with respect to them a category mistake. They are wanting to argue the case on the basis that somebody that should have been there wasn't there. That, in other words, there was an absence. That's entirely wrong. What it is this is a case about whether somebody could be acting in substitute, who was there, but was in substitution of the person that the Constitution has indicated should be there. So it's a very different case. And the question then really is, are there good reasons for why that person was there? And I think our learned friends for the JSC have explained that. And secondly, was it permissible for them to be able to delegate in circumstances where they realized they were conflicted? Were they permitted to delegate to Justice Mba what they thought was a critically important moment, obviously in the JSC's history, to ensure that there was somebody to take their place? No doubt, had that not happened, there would have been a review ground in that context, I suspect, by our learned friends. And in that context, delegation, we say, certainly should be doing appropriate work. I might add that there was a question from, I think, my lady, to our learned friends around the issue of delegation under the Constitution and the question of Section 238, agency and delegation.
Yes, it seems to be an executive, enabling the executive to delegate, is that?
We see that, but we can't see where the JSC would otherwise fit in. It's certainly an organ of state. Right. It's not a judicial organ of state. It's not a legislative organ of state. It is, we think, probably, certainly because it's not the first two, it's not judicial and it's not legislative, it's probably an executive organ of state. And then when one looks over at the 239 section on definitions, we think we might be right in that contention, because it says an organ of state means any department of state or administration in the national, provincial or local sphere of government, and then importantly, or any other function or institution exercising a power or performing a function in terms of the Constitution. And here, clearly, the JSC is performing that function. And so we think you could well fit under, as Mr. Tube pointed out, you're talking about how to understand the constitutional scheme to effect accountability when a judge is accused of gross judicial misconduct. You've got to read all of these provisions in a way which is going to give them meaning and purpose. And in that context, it would, we think, be helpful to read the JSC and the officers in this case as being permitted to delegate between themselves in a way which allows the JSC to continue its work rather than to be hamstrung and not perform that function.
Right, thank you. I'll ask Mr. Masuku about that tomorrow.
Let me also just pose a question.
Of course.
What about costs?
Oh. I'm sorry, I should have started with that. Well, my lords, my lady, I think in our heads suggested that if we were to be successful alongside the other respondents in resisting the review, that freedom under law would be entitled to its costs, in the same way that I think we were entitled to our costs in the intervention application. But that if we weren't, then that in light of the fact that freedom under law is obviously acting in the public interest and its NGO status, that it would be covered by BioWatch.
May I ask a question arising out of what has been said now? Going back to the question Judge Victor put to you about the composition problem, I understood Judge Hlophe's case to be slightly different. There is a complaint about what the absence of the president or deputy president of the SCA meant for the integrity of the Judicial Service Commission. But there's also, as I understood it, a contention that if it is to be found that Judge Mba had no basis to be there, his presence contaminated the decision. And do you have anything to say about that?
Well, I suppose we along the lines of what I'd earlier said, I think we would struggle to understand how that contamination could be. Because if the debate is, Justice Sutherland, whether the composition of the JSC, where there's somebody who finds him or herself conflicted, or they have to perform a function before a commission of inquiry, or they're ill, are they able to find a way to keep the JSC continuing in circumstances where, as we know, there are good reasons for them explaining why they weren't able to be there in their own body, and they therefore want their office to be represented by somebody else in the form of a different body, in the sense of a human body in the form of justice and bar. Well, we would say that would be perfectly valid and purpose-directed at ensuring that the JSC continues its work. So it wouldn't be a case of contamination, it would be a case of continuation of that which we say ultimately the JSC needed to perform here. And our learned friends, I think, for the JSC put it as well as it could be put, and they put it very well, if I may say, that there needed to be an accountability handed to this particular process. If you don't give this particular process some form of meaning by reading these provisions holistically and together, then you effectively mean that there was an impunity, an unaccountability moment that arrived for the JSC, and that can't be right on the contamination line that our learned friends have suggested.
Thank you.
Okay, thank you very much. For tomorrow's proceedings, we'll hear Advocate Badlander and Advocate Masuku. I hope you're still there. We intend giving you 1 hour in respect of your reply tomorrow. I think that would be enough.
I don't think so, JP. I am responding to arguments that are raised by a considerable number of people who have not considered a single point. All the points that I've raised are contested, and I would urge that the court be patient with, be generous with its time, because the proceedings have raised a considerable number for us to think about and to respond. But again, I've got an evening to think about what it is that I must target for rebuttal. But everything is contested.
Okay, if you say we should be generous with you, can you give us an indication?
I would say
we'll be having time to reflect on everything. What do you think would be a reasonable time?
I would say 2 hours, and my learned friend, for my colleague Titagi will take the other bit of the reply.
I think we can give you an extra hour.
Thank you.
Okay, thank you very much, Cordula Jen. We'll start tomorrow at 10 o'clock. Cordula Jen.